Please, your lordship. Lordship, in item 63, we have filed an additional affidavit, lordship. Kindly call for the record, lordship.
Yes,
Deeply obliged.
Lord, may I pray for listing of three matters, my lord, arising out of the selection process.
Thursday,
On Friday.
on Friday.
Friday.
But item number 16, I have some difficulty today. Item number 16 after the vacation.
Item 16 on the prayer of Mr. Ganguly Learned Council for the writ petitioners. This matter stands adjourned, list again after the summer vacation.
May I please, your lordship, I beg to mention for listing of an motion matter on Friday, my lord.
Outline, may I please, lordship. Lordship, in connection with item number 72, my lord, I have filed an additional affidavit. My lord, kindly allow to the affidavit to bring on record, my lord.
Yes.
Kindly.
May it please, my lord, I beg to mention item 98 of today's list. My lord, it may kindly be taken up with item 23, the connected compassion appointment cases.
Yes.
Highly obliged.
Your lordship, I beg to mention item number 64, lordship.
Sorry,
64.
yes,
Matter may be adjourned for a week, lordship.
there may be adjourned, 64.
64.
It's come for orders.
Lordship, we could not contact our client, lordship.
Okay, you wait, we'll pass an order when the matter reaches.
May I please, your lordship, I beg to mention three writ petitions
Hmm.
on Friday, that is 36th.
For
motion. Your lordship. Kindly oblige.
Back to mention on contempt case for orders after vacation, my lord.
May I please, your lordship. Lordship, I beg to mention two writ petitions, lordship, for admission after vacation. Highly obliged.
May I please, your lordship? I prefer listing case matter for tomorrow because urgency is because today I have filed, my lord. Urgency is this, my lord. Petitioner will be lordship disabled due to impairing of hearing. In this regard, certificate is issued. On the basis of this certificate, I appeared in the interview conducted by ONGC. Then I got selected. Offer appointment issued. There is a performer by medical officer.
Yes,
to
yes,
fill up.
yes.
Tomorrow, my lord. 29 is the update. That's right.
You're happy?
Happy, my lord.
My lord, matters pertaining to reservation in promotion, my lord. He challenged the recommendation of the private respondent. My lord, the finance department were asked to bring the records. My lord, copy of the departmental selection committee's minutes has not been furnished to me, my lord. In the minutes, my lord, contrary to the law laid down by this court, my lord, they recommended the name of the private respondent, who is a STP candidate, my lord. My lord, the entire roster was set aside by this honorable court on 2016. No appeal was filed. That order has attained finality, my lord. Now in the DPC, they have considered that according to roster, private respondent name was recommended. That's why I'm before your lordship challenging the minutes, man.
My lord, Mr. B. Chaudhary is appearing for this matter. He's on his way. My lord, or else we have get one notification from the department. The department is praying for 1 month time to submit parawise. My lord, I brought this before this honorable.
Done in time, but no promotion notification till next day.
My lord.
Deeply.
Mr. Yes.
Here for respondent 7. Wrong information has been given to the court that the roster, L roster was quashed. L roster cannot be quashed because L roster is a part of the 2000 amendment. So it was never quashed. In fact, there is an order of this court putting an injunction which has been heard by the lordship will take up page 88. There is already an injunction obtained by my learned friend at page 88 where an injunction is there and I have been selected. And against the fifth point belongs to the STP. No one can challenge. The roster was never quashed. That's a wrong statement. And at page 88, lordship, the order is very clear. Any promotion will be with the leave of the court. So there is already an injunction at 4319, same petitioner, same respondent. So the government may produce the record. We are ready with the affidavit.
Correct. What is the other matter is pending?
Yes, lordship.
And
it was heard at length 4319 of 2021. He only appeared.
4319 of 2000.
Yes, 21, where an injunction has been given, I filed a vacating application that is awaiting.
So in
My
any
lord,
case,
my
just
lord,
a
that
minute.
matter is
Mr.
under
Bhatt.
CAV, my lord.
He is entitled to
My
make
lord,
his
my lord.
submission. If you have something to say, we'll hear
Yes,
it,
ma'am.
no
Yes,
problem.
ma'am. Sorry. ma'am.
So in any case, the promotion cannot be issued unless.
Unless that
order.
order. So your lordship will not pass any interim order for the second time. That's my prayer. And I'll give a detailed.
No,
affidavit.
will not pass, but we'll say that because of that order, no promotion can be issued.
Yes.
Until leave is granted.
Leave is granted. Because there I have already filed a vacating application.
Only thing, his submission is totally wrong, my lord. Page 87, my lord.
Mr. Boishyo,
My lord,
making submissions includes the right to make wrong submissions.
yes, my lord.
You must
Yes, my lord.
understand that.
Something cannot be tolerated, my lord. Sorry, my lord.
Anyways, heard Mr. G. Boishyo, like counsel for the lead petitioner. Also heard, you are appearing for?
I'm appearing for B. Chaudhary, my lord.
Also heard Mr. B. Chaudhary, learned standing counsel, Finance Department,
Finance and taxation.
Finance and Taxation Department, Assam, who submits that instructions as called for in terms of the order dated 21/6/2023 is still awaited, and therefore 3 weeks further time be granted to the department to obtain instruction and file affidavit. Mr. Mr. D. K. Das, learned counsel for the respondent number 7, on the other hand, submits that the writ petition has been filed on an erroneous projection of facts. According to Mr. Das, there is already an interim order operating in a connected matter, being WPC number 4319 of 2021, which is pending disposal before this court. And therefore, the question of issuing any order of promotion without the leave of court does not arise. First up, the learned counsel for the respondent number 7 has also, therefore, prayed for some time to file counter affidavit. First up, responding to the above, Mr. Boishyo submits that the department is yet to furnish him with a copy of the minutes of the DPC proceedings. First up, give him a copy of the.
Here the issue is that Lordship DPC has been done, no promotion order has been issued. Only since the WPT BC department and personal dependence of the administrator with regard to the reservation, their views has been sought.
All
So
right.
till that.
All right, since the department has already prayed for time to file a detailed counter affidavit, this aspect of the matter will be dealt with at the appropriate time. Issue notice of motion returnable on 19th of July, 2023. Since Mr. Chaudhary has appeared and accepted notice, who is appearing for whom?
Lordship, I am appearing on behalf of respondent 1, 4 and 5, Lordship.
Acha, since Mr. J.K. Goswami, learned additional government advocate Assam, has appeared and accepted notice for respondent numbers 1,
4 and 5, Lordship.
4 and 5. Mr. B. Chaudhary for respondent numbers 2, 3, Huh?
Appearing for 6, 6.
2 and 3. Mr. R. Dhar, learned SC, WPT and BC for respondent number 6. No formal notice is required to be sent to the respondent numbers 1 to 6. Extra copies of the writ petition be furnished to the learned departmental counsel. You are on caveat, Mr. Das?
No, my lord, I appeared, I got the information and I've been. My client.
He's always there.
He was promoted, so he was little bit vague. He was my earlier client also in that.
Oh. Legacy, good legacy. Mr. D.K. Das submits that he has instructions to appear on behalf of respondent number 7 and the wakalat number will be filed
As
within a
already.
week from today. In view of the above, service of notice on respondent number 7 is also deemed to be complete in this case. What is 8?
8, Lordship, I am appearing on it.
Acha. So J.K. Goswami 8 will avoid. In view of the above, service of notice upon the respondents is deemed to be complete in this case. Let this matter be listed again on 19/7/2023 along with WPC number 4319/2021.
My lord, that writ petition is under CAV, my lord. Matter was heard and judgment
Then
was.
this part
reached.
is not required. Having regard to the facts and circumstances of the case, it is hereby provided that no notification of promotion of the respondent number 7 shall be issued will be issued till the returnable date.
Deeply observed.
Anyway, the promotion of respondent number 7 shall not be notified till the returnable date.
May I please, Lordship? This is SS3 matter, Lordship. Sub-selection commission appointment of constable in different.
Yes, but yesterday's order, we said that subject to availability of vacancy.
Yes, Lordship.
So, Mr. Roy, you were there in another matter yesterday. There, now we are saying subject to availability of vacancy, they will consider the case. What is the case number? Can you give
Lordship,
yesterday's order?
3708 of 2013, 23.
Give it to him. Little same order, similar. Mr. R. Sharma, Mr. S.S. Roy.
In item number 2, my friend will appear, Lordship.
Achha, in item 2, your Mr.
if you-
H. Gupta.
And item number 10 also same, Lordship.
Mr. H. Gupta will appear.
In the item number 10, I am appearing.
अच्छा, item 2 CGC नाम देबो Mr. H. Gupta और item 10 नाम देबो Mr. S.S. Roy. बाकी both are single petitioner.
No, in item 10, there is 2 petitioners.
अच्छा, तो item 10 और double petitioner. I can modify the one of single petitioner. बाकी order तो एक ही होगा. Can you give the order, please? Disposed of 2 and 10. Disposed of.
So, item 10 is ST and item 2 is OBC.
अच्छा, item 2 OBC candidate, item 10 ST candidate. এই modification গুলি করলে order side type.
Of that.
My lord, item number 7 is also there, similar, Lordship.
Item 7 also similar.
Single petitioner, my lord.
7 single petitioner,
OBC.
Mr. H.R. Ahmed, petitioner, S.S. Roy, CGC, single petitioner, OBC, same order, disposed of. Item
Published.
7 also disposed of.
Item 3.
May
2, 7 or 10.
Lordship, in this case, Lordship, similar order is there, Lordship. Item number 3, 89, 90, 91, and 96 will similar.
Item number 3, 89.
90, 91, and 96.
So all petitioners council, you are the,
Lordship.
Yes, Lordship, I am appearing for all these petitioners, Lordship.
so you are Mr.
NH Lashkar, Lordship.
Mr. N.H. Lashkar. So the date of physical test is 6/5/2023. Yes, 389, 19, 91, and 96 disposed of.
Mere Lordship. Lordship, the petitioner is assailing the order dated 31st May 2023, that is annexure 2, my lord, page 18. Whereby the petitioner is invalidating order from service with effect from 30 June 2023, my lord. He is aggrieved by the provision of the rule 26 of Assam Rifle Rule 2010, my lord. The petitioner to seek review of the order of obtaining the opinion from the civil government doctor, my lord. That has not been followed, my lord. kindly see page number 19, annexure
So he
3.
has already been released,
No,
already.
my lord,
released.
on 30 of June, my lord.
He will be released.
The medical, he is aggrieved by the provision of rule 26 of Assam Rifle Rule, my lord, that is annexure 3, page 19, my lord.
So you are challenging the rules.
Yes, my lord. No,
Then it has to go to division bench.
no, my lord, we are not challenging the rule,
Hmm.
but that rule has not been followed, my lord.
What is the rule? Let us see.
Kindly see, my lord, page number 20. Rule 26, my lord. Page number 20, rule 26,
Hmm.
para 3, my lord.
So have you made any application for?
No,
review?
no, my lord, that opportunity has not been given to me. That's why I am before your lordship, that simply way to allow me to take the opinion from the civil government as per this rule. Till then I may be protected. my lord.
So, yes.
He has not submitted any representation before the authority. And
So you submit representation, they will
No,
consider.
no, my lord, first they should have.
What? No, no, you can't say no, no to the
No,
court.
my lord, my lord,
You are no one to say no, no or yes,
my lord,
yes.
my lord, my.
That is the order will pass. You complete your argument. You go and submit a representation, they will
My
consider.
lord, my humble prayer before the lordship, first they should given the medical opinion and medical review board to me as per this rule.
Hmm.
Then after I will take the opinion from the civil doctor, my lord. Thereafter I will make the representation, my lord.
whether medical review has been served to him or not in this regard, I have to take instruction, Lordship.
Then we'll issue notice and stay the order. There is no other third alternative is not there.
Yes, Lordship.
You
It-
choose which do you want.
He may file a representation before the authority.
Till such time the representation is answered, he will not be discharged. That's the order will pass. What else?
Yes. Otherwise, I have to, 2 days time will grant it to, day after tomorrow, I can take instruction. If not then. Authority, Lordship may
My
pass.
lord, there is another rule in Assam Rifle, that is page 22, my lord. Kindly see, my
All
lord.
right, then let her obtain instruction. We'll have it on then 30th. 30th.
30, yeah.
30th, my lord, they will be.
29, Lordship.
Sorry, then we will have it before another court. I cannot address this argument.
My-
Let this matter be listed before any other bench without.
Then 30th, my lord.
Mr. So-and-so is present on behalf of the petitioner on the request to Ms. S. Barua, Lanet CGC. This matter is directed to be posted again for motion on 30th of June 2023. So as to enable the Lanet CGC to obtain instruction as to whether the procedure prescribed under Rule 26 of the what is that?
Assam
Assam
Rifle
Rifle Rules
2010.
have
my
been exhausted in this case before taking the decision to discharge the petitioner. First up, if not, why such an opportunity be granted to the petitioner before the order of discharge from service is implemented? And if not, why an opportunity should not be granted to the petitioner to avail remedy under Rule 26 before the order of discharge from service is implemented? Full stop. One extra copy of the writ petition be furnished to Ms. Barua during the course of the day.
My lord. Leave your lordship.
Yeah, please, your lordship. No, this is regarding compassionate appointment, my lord. My case has been rejected by the state level committee due to lack of vacancy, my lord. Page number 11. The state level committee may consider, my lord, any other department might be as well.
So what can be done here?
My lord, my
If
case,
there
may
was no vacancy, then how will they appoint?
be- any other department, my lord, my case may be considered.
No, but the application is of 10 years back, 2023.
And regarding his age, it's so doubt, Manoj. 2012, he fathers died and he passed ACLC only.
Now he 30 years, it's a minus, then he is 11 years. How he can apply? That is also, Lordship kindly see page paragraph 2. Department, he died harness during the tenure of service on 1/3/2012, leaving behind his widow so and so. The petitioner passed SSLC examination in the 2012. 2012, he passed SSLC most probably 16 years, 15 years like that. And now he's 30 years. If minus, then his age will be 12, 11 years. Otherwise, and he has not challenged the rejection of the SLC.
My lord,
So his date of birth is given 29th of January 1993.
my lord.
But no annex is there.
No, no, it's there in Annex
Yes,
one,
one.
you mentioned, page 10.
But he has not challenged the rejection of the SLC. The petitioner, and is a old case, 2012.
Hmm. This can be done under which notification?
Hello?
Other department, it can,
1/6/2015 notification.
it will not be applicable in your case.
My lord,
Your application was filed before the notification came into force.
my lord, as per as NC Santosh case, my lord, at the time of consideration, my lord.
Hmm.
And
Then
my,
at the time of consideration, the scheme was withdrawn. That will
And,
not be of any help to you.
uh,
See, if
and-
you take at the time of consideration, then the prayer has to be dismissed because on that day the scheme was withdrawn. If you take it at on the date of filing the application, then also your prayer cannot be accepted because on that day the notification was not there.
and I was rejected, my lord, as per 1/6/2015. My lord, below the table, my lord, kindly see, page number 11, my lord,
Page number 11.
11, my lord. Below the table, my lord.
No, it says 7/12/2019. Meeting was held on 7/12/2019.
My lord, but as per clause, as per notification dated 1/6/2015, my lord, my case has been rejected.
So no vacancy under 5%. No vacancy under 5%. Compensation appointment only under 5%.
These matters have nothing now. It's unnecessarily, we'll close it. And what is the date of the notification which allows other departments?
1/6/2015.
And you're relying upon some judgment. Your case is not covered by 1/6/2015. Do it
Then-
after
then-
vacation. then.
My lord,
After vacation. On the prayer of Mr. Sohil counsel for the petitioner, let this matter be posted for motion again after vacation. Mr. T. Stutia, learned additional senior government advocate Assam is present on behalf of the state.
my lord, here in this case, my lord, SLC has considered our case but not appointed yet, my lord. Page number 18, my lord,
Page number 18.
18, my lord. SLC minors. My lord. In the table, my lord, serial number 1, Ratul Tetia, my lord, right hand side, my lord, recommended for appointment, my lord. Number, then my lord, serial number 8.
Yes,
5% under the 5% quota on other department.
Hmm.
This instruction has to take by the, have to take by the
all right, I heard
department.
Mr. F. counsel for the petitioner. Here was the averments made in the writ petition. The grievance of the petitioner is that although the state level committee bracket SLC in its meeting dated 02/03/2023 had considered the application made by the petitioner for appointment on compassionate ground and recommended his appointment against a grade 4 post subject to availability of vacancy under the 5% quota in other departments no steps have been taken till today to issue the order of appointment. Mr. Ms. S. Borua, learned Government Advocate Assam, appears and submits that whether 5%.
Just one line. Lordship, may kindly see at page 11, Lordship, what was the direction passed, Lordship? Lordship, may kindly see the last, the petitioner to submit a certified copy of this order before the executive engineer mechanical, etc. Who shall do the needful to place the same place the application of the petitioner before the DLC.
My lord, thereafter.
Oh, let him submit. You take your
Lordship,
seat.
I think in this case, Lordship, instead of DLC, matter was directly placed before the SLC, Lordship. And accordingly, SLC passed that order without knowing whether any vacancy is there or not, Lordship. Lordship, may kindly see the SLC at page 90.
Therefore, we are issuing notice only. What is the problem? We are issuing notice only. This
Lordship will kindly record this, otherwise case will go
No,
other way.
You come up with your affidavit. I will record your submission.
Lordship.
Mrs. Borua, learned Government Advocate Assam, prays for some time to obtain instruction. Mr. P. Nayak, learned Standing Council,
I will pay for finance. Lordship.
Finance Department, Assam, appearing for the respondent number 2, Borua for 1 and 3. He submits that the case of the petitioner was not routed through the DLC, but was directly placed before the SLC without, and the recommendation was made without ascertaining the vacancy position. Hence, the delay in the matter without ascertaining as to whether vacancy is available in other departments. No relief can be granted to the petitioner. The learned Standing Council Finance, however, prays for some time to seek instruction and file affidavit.
Lordship, government laws,
That's it.
DLC laws.
The learned Departmental Council, however, seeks some time to obtain instruction and file affidavit. NOM 6 weeks,
Yes.
since the respondents are already presented, no formal notice, extra.
May please his lordship. My lord, the petitioner before the lordship is a Gram Rozgar Sahayak, my lord. And he was terminated by order dated 14/3/2023, my lord. That is at annexure 8, page 41, my lord.
Yes.
What happened in this case, my lord, in this present case, my lord, there was an FIR and complaint case against the president, vice president and ward members, my lord, for not extending the benefit under PMAU, Pradhan Mantri Gramin Awas Yojana scheme, my lord. So one of the beneficiary filed a case against them, my lord. Lordship will find, my lord, at a page. I have annexed, my lord.
This is covered under the earlier judgment.
My lord, I have annexed, my lord, but no notice and nothing was.
Where is the judgment, earlier judgment?
My lord. 40. My lord,
Page 40?
44. My lord, it starts from page 43, my lord. Annexure 10, last annexure, my lord.
Any appeal has been preferred against this judgment?
Well, there's a slight difference between the judgment. In your previous judgment, my lord, there was an inquiry that was held behind the back of the petitioner. And the second thing was that on a bare perusal of the termination order, it was stigmatic in nature. Whereas in the present termination order, no inquiry has been held behind his back. His termination is completely covered under clause 9, which is in page number 19, my lord.
No, it says it is embarrassing for the employer.
Exactly.
Because embarrassing, it's
It is
like
covered.
the motive of termination,
Embarrassing
it's
is
not
a-
foundation.
The certificate. of
My lord,
good-
his
good-
FIR, he's going to judicial custody, he is being arrested. So like, on that ground, it was embarrassing for the employer. So that is covered under clause 9, page 19, my lord.
My lord, I'm not.
My
disputing.
lord, may just kindly have a look at page 19.
Yes.
First, second, third, fourth, fifth, sixth, seventh line.
Yes.
Or if the employee is found to be involved in any act that may become embarrassing to the employer. So on this ground, my lord, since he was arrested,
No, Mr. Mr. Henry,
Handik, my lord.
see, you may have the right to terminate, but we are not on the right to terminate, we are on the procedure followed. Anybody can be terminated. But does it mean the termination can happen in any whichever manner one
My
wants?
lord, this is not a stigmatic, it's an innocuous order. It's a
That
simplistic.
could be a different reason. You can say the reason is different, but nonetheless, it is violative of principles of natural justice.
It's a motive, not the foundation, man. That's my humble submission.
Why don't you issue a notice, hear him and then take a decision? What is the problem with that?
As my lord wishes.
Huh?
My lord wishes. In that case, my lord may direct that the same procedure that was followed in page 46 of your impugned order.
Hmm.
Oh,
Hear him and then terminate. He doesn't have it. There is another judgment, which is I think of 2011 or 12, where this court has said that what will be the outcome of the process, the court cannot presume it. You have to give him a
Reasonable opportunity.
You said continuance will be embarrassing.
yes, my lord, that's it. And as per the, we just copy pasted the language from clause 9, my lord. This is embarrassing because he was in judicial custody. He was arrested.
My lord,
Or if the employee is found to be involved in any act that may become embarrassing to the employee. So clause 9, my lord, we have
if an.
Simpliciter,
If
termination
the act done
simpliciter.
by the petitioner, my lord.
Why, what is this case? Police case 279?
My lord, page 26, lordship is having, my lord. Page 26, that is the first ajar, my lord.
Let us see what is the ajah.
Yes, my lord. Accused person is Selina Begum and Baharuddin, my lord. Page 26.
So the petitioner is in jail now, judicial custody.
No, my lord, he was arrested on 5/3, my lord, and on 18/3 he was released by the London Chief Judicial Magistrate, my lord. We have annexed his order, my lord, will find at page 38, my lord. This is the type copy. my
He was
lord.
in judicial custody till 31st March 23.
No, my lord, not 31st March, 18/3, my lord, he was granted bail and matter was fixed on 31st/3, my lord. Monatush Pal, lordship will find para 3, my lord, from the top.
No, he was remanded back to judicial custody.
Yes,
He's
my
right.
lord. That has
Yeah.
caused embarrassment to the employer.
One suitable, my lord, hence accused Manatush Pal is allowed to go on bail of rupees 10,000, one suitable
Yeah.
surety in default to remain in judicial custody, my lord. In default, my lord. ID was this. My lord, and later on, my lord, that we have typed, my lord, later on, one bailer, Jamaluddin submitted.
All right, you take down heard Mr.
M.A. Chaudhary.
M.A. Chaudhary, learned counsel appearing for the writ petitioner. Also heard Mr.
P. Handick.
P. Handick, learned standing
behalf of
counsel,
PNRD.
PNRD Assam, appearing for the respondent numbers
Respondent numbers 1, 2, 4, 5, 6, 7, madam.
1, 2, 4, 5, 6, and 7. And Ms. M.D. Bora, learned government advocate Assam for the respondent number 3. First up. This writ petition has been filed assailing the order dated 14/3/2023 issued by the
Commissioner Panchayat and Business.
respondent number 7, terminating the contractual service of the petitioner on the ground that
My lord, it
Is-
was issued by the Commissioner Panchayat and Rural Development, my lord, and exactly. Vikram Kairi, IS Commissioner, my lord.
is respondent number
1, my lord, Commissioner Secretary.
by the respondent number 1, not 7. Terminating the contractual service of the petitioner on the ground that his continuance in service was embarrassing for the employer. The impugned order was apparently issued by invoking clause 9 of the contract agreement,
Talks
which
about
permits such a recourse if the if the inter alia, no, if the employee is inter alia found to be involved in any act that may become embarrassing to the employer, full stop. It is to be noted herein that the writ petitioner herein was engaged on contractual basis by order dated 30/4/2010 to function as a
Gram Rozgar Sahayak.
Gram
Rozgar Sahayak.
Rozgar Sahayak, pursuant whereto he had joined service and was continuing till such time the impugned order dated 14/3/2023 was issued, full stop. It appears that one, where is the FIR?
On page 26, madam.
It appears that
Page 26. madam.
an FIR was lodged by one Intaj Ali.
Intajuddin, madam.
Intaj Ali.
Intajuddin, madam.
Intajuddin
Intaj.
with the officer in charge of Ratabari Police Station alleging
Along with the complaint case also, my lord,
Yes.
which is at page 30.
alleging that the petitioner was responsible for depriving his brother, who is a disably able person, from allotment of house under PMAY scheme to another villager in lieu of money, full stop. It also appears, based on the aforesaid FIR,
Page 38, madam. Bail.
Ratabari PS case number 279/2022 was registered and petitioner was also arrested on 5/3/2023. Full stop. He remained in judicial custody till 18/3/2023, whereafter the petitioner was released on bail. It is in the aforesaid backdrop that the impugned order was issued without serving any show cause notice upon the petitioner, full stop. Mr. So-and-so learned counsel for the petitioner submits that the case of his client is squarely covered under the order dated, judgment and order dated 01/06/2023 passed by this court in WPC number 2977/2023, granting relief to similarly situated employees whose contractual services were terminated without serving any prior notice. Full stop. Responding to the above, Mr. Hendrick submits that in the case of Ali Ahmed Borbhuya versus State of Assam and 6 others, bracket A WPC 2977/2023, this court had observed that the order of termination was stigmatic. First of, it was on such basis that the order of termination was interfered with and the matter was remanded for a fresh decision after serving prior notice upon the employee. Full stop. However, this is not a case, according to Mr. Handy, where the order of termination is stigmatic. Full stop. In order to evaluate the submissions made at the bar, this court had carefully examined the clause of the clause 9 of the contractual agreement, as well as the order of termination dated 14/3/2023. Full stop. As noted above, the order of termination clearly mentions that continuance of the petitioner in the backdrop of his arrest and detention in connection with Ratabari Police Station case number 279 of 2022 was found to be embarrassing for the employee. Full stop. It must be borne in mind that mere arrest of a person in connection with a criminal case by itself does not declare him to be a criminal or guilty of any offense. Full stop. Until and unless charge sheet is submitted, it cannot be said that there is a criminal proceeding pending against the person concerned. Full stop. Moreover, it is the salutary principle of law that no person can be treated to be every person should be presumed to be innocent unless found to be guilty by following the proper procedure of law. Full stop. Next para. In the case of Ali Ahmed Borbhia, bracket Supra, this court had dealt with a similar matter where order of termination of service was issued without serving any prior notice. It was found that the order of termination, which mentions about misconduct on the part of the petitioner based on a domestic inquiry conducted behind his back, was stigmatic on the face of the record. First of all, on such basis, this court had set aside the order of termination and disposed of the writ petition with the following observation. Double tick page 45. To double tick page 46. Full stop. Full stop. In the instant case also, the mere use of expression embarrassing for the employer within court used in the backdrop of the pending criminal proceeding against the petition, in the backdrop of the pending police case, in the backdrop of registration of the police case and his arrest made in connection therewith, clearly projects the petitioner as a sinister, thereby casting a stigma upon him. Moreover, the fact that an FIR has been registered against the petitioner,
My lord,
alleging, yes,
it is
yes.
not against the petitioner, my lord. Vice President and her husband, my lord. My lord, page 26. Accused person, Selina Begum and Baharuddin, my lord.
Achha.
Selina Begum.
Moreover, merely because an FIR has been registered where the petitioner is not even an accused person, it cannot be said that he has been found to be involved in any act that was embarrassing for the employer. Full stop. Having regard to the facts and circumstances of the case, it is found that the decision of the respondent number 1 to terminate the service of the petitioner was hasty and in clear violation of the principles of natural justice. Therefore, this court has no hesitation in coming to the conclusion that the case of the petitioner would also be covered by the decision of this court in the case of Ali Ahmed Borbhia Supra.
My lord,
Consequently-
in that case, my lord, page 46, para 2 and 3, my lord had passed the next course of action. So
Yes,
let us
sir.
follow that same course of action.
The order of termination dated so and so is hereby set aside. However, if respondents are granted liberty to follow the same course of action as has been provided in the order dated 01/06/2023, rendered in the case of Ali Ahmad Borbhia, bracket Supra, even in the case of writ petitioner.
Obliged, your lordship.
With the above observation, the writ petition stands.
My lord, may I point out one thing, my lord? Lordship has recorded the termination order is issued by the commissioner and secretary, but it's the commissioner. Commissioner is a different post, my lord. Lordship may kindly record, it's commissioner. Commissioner is not a party here, in fact.
Okay, Commissioner, Department, Commissioner of
PNRD Assam.
PNR.
Yes, yes. Thank God that he has made some government official as party. Something is okay, because judges are still accepting it.
My
The
lord.
day you dismiss a petition for this ground,
Yeah.
then people will wake up.
My
We'll do it very soon, don't worry. That day is coming.
Lordship, may it please this minor. The petitioner retired as Assistant Director, Department of Food, Civil Supplies and Consumer Affairs, your lordship. But order dated 30/6/2015. What happened, your lordship? His promotion, he was promoted from inspector to superintendent in the year 17/11/2019, which I have annexed as Annexure A, with retrospective effect from 7/2/2009. Lordship, that benefit has not been given to him, your lordship. On the point that there's a delay in joining, lordship.
We'll have to issue rule,
Yes, ma'am.
notice, rule or notice.
Notice on.
Not rule.
No,
Nobody wants rule.
no.
Rule of law is gone.
It takes time, your lordship.
All right. But now admission is going to take much longer time than hearing. Because everything is coming for admission. So hearing matters will be listed after motion, after vacation. Final hearing, first motion, then final hearing, then orders, then admission.
Then I leave it to your lordship, whichever is early.
But Ms. Bibhuya, learned senior counsel, assisted by Ms.
Harris Theory.
Theory, learned counsel for the petitioner. The writ petitioner hearing is agreed by denial of benefit of the ROP rules 2010 on the ground that there was 79 days delay on his part in joining in the promotional post. Full stop. Ms. Bhuya submits that the delay was due to non-release of the petitioner from his previous post of inspector and not attributable to any laches or negligence on the part of the writ petitioner. First of Mr. J.K. Goswami, learned additional senior government advocate Assam, prays for time to seek instruction and file it.
1, 2, 4, and 6, lordship.
Issue notice returnable in 8 weeks. Since Mr. Goswami has appeared and accepted notice for respondent numbers 1, 2,
4 and 6.
4 and 6.
KK Mehdi
Mr.
appearing
A. Cholia, learned SC Finance for respondent number 3, and Mr.
KK Mehdi.
A.K. Mehdi for respondent number 5. Service of notice is deemed to be complete in this case. Extra copies of the writ petition is furnished to the learned department council within a week from today, so as to enable them to obtain instruction and file it.
From the post of inspector to the post of superintendent. There's a delay in joining.
Actually, from the post of inspector to the post of
Superintendent. Obliged.
just announce it, we'll call it accordingly.
Item number 86, 87, 88, 93, 94, 95, and 97 will be taken up after the admission practice, as ordered yesterday. For motion supplementary list, item 92.
Mr. S. Bhattakur appears in this matter. He is in court number 2 on Lake. Can it be?
What is the matter?
My lord, matter pertains to retrenchment of 11 employees of the ASTC who are on contractual service, your lordship. And before.
Similar matter tomorrow.
As a posted tomorrow, we'll have it tomorrow.
Lordship.
All right. Heard Mr. S. Dev,
My lord,
counsel for-
AG sir is coming, lordship, he is appearing. in this-
We'll have it tomorrow.
Tomorrow, my lord, my lord.
For the petitioner, Miss M.D. Bora, learned government advocate.
This
Assam
is standing council transport.
Service
Department.
and Council Transport Department of some submit the similar matters are listed before this court tomorrow. And therefore, this matter be also taken up together.
My lord.
You have the case number
Lordship, I will provide.
in view of the above let this matter be listed tomorrow for motion along with, to be taken up along with
I'll give
WPC
another.
number so and so and the
Huh.
connected matters.
Organize that.
Tomorrow.
Much obliged.
Order impeachment for party item 11.
May I please, your lordship?
Yes.
During the pendency of the writ petition, Lordship Director of Social Welfare has been divided into two. One is Director of Women and Child Development and other is Director of Social Justice. But the service of the applicant falls under the Director of Women and Child Development. So Lordship, my humble prayer before your Lordship to implement Director of Women and Child Development as a respondent number 7 in the writ petition, Lordship.
All right. Yes. Anything you have to say? Mr. Chutia? You take down, heard Ms. R. Kakati, learned counsel appearing for the applicant. Also heard Mr. T.C. Chutia, learned additional senior government advocate Assam, appearing for the official respondents. First of this IA has been filed with a prayer to implement the Director, Women and Child Development, Uzan Bazar, Guwahati 1 as respondent number 7 in the connected writ petition. First of Ms. Kakati submits that when the writ petition was instituted, there was one common directorate in the form of Directorate of Social Welfare. First of However, during the pendency of this writ petition, the aforesaid directorate has been bifurcated by creating two new directorates. First of at present, the petitioners come within the jurisdiction of Director of Women and Child Development, Uzan Bazar, Guwahati. Hence, this application for implement. Mr. Chutia has not disputed the statements made in the IA. In view of the above and considering the ground on which the IA has been filed, the same stands allowed. It is hereby ordered that the Director, Women and Child Development, Uzan Bazar, Guwahati 1 is implemented as respondent number 7 in WPC number 6683 of 2017. First up, the applicant to file an amended cause title in the writ petition, IA stands disposal. You have to file an amended cause title. You know now there is a new rule.
Yes, Lordship.
Just the cause title you change it
Course.
because it has to go to the CIS.
Yes, Lordship.
Otherwise, when the order certified copy comes out, somebody else's name comes in.
Always.
For exhibition item 12.
What if this petitioner has remained absent continuously? What is this matter? Take down, none appears for the petitioner. Mr. J.K. Goswami, learned additional senior government advocate Assam is present on behalf of the official respondents. In this writ petition, the order of appointment of the private respondent number 5 as Anganwadi worker of Subahi Madrasa resident Suburi Anganwadi Center has been put under challenge. Full stop. This writ petition was filed way back in the year 2016. However, there is no interim order of stay suspending the operation of the order of appointment of the respondent number 5. Full stop. I also find from the records that the petitioner's counsel has not only remained absent on the previous occasions as well, but even The Lojima Court order dated 02/12/2021 goes to show that the counsel for the petitioner did not appear when the matter was listed before the Lojima Court. From the above developments, it appears that the read petitioner has lost interest in pursuing this matter before this court due to long lapse of time. Consequently, this read petition stands dismissed for non-persecuted.
Item 13.
May it please your lordship.
Yes.
My lord, the matter relates to retrenchment of the three read petitioners.
Lordship, I am appearing on behalf of London CGC, Rita Devi, Lordship. So she is on legs, Lordship. Matter may kindly pass over for a time being. Lordship.
What is this case about?
It is that, my lord, facing an situation of retrenchment, they had approached the honorable court. The honorable court passed an order, issued a notice of motion, passed an order staying that process. Now, in defiance of that, sometimes in the month of October 2016, they were retrenched. Some letters were issued to their name. But although the affidavits were filed by the respondents, my lord, there was a whisper that the retrenchment order was passed, but the retrenchment order was never brought on record. Subsequently, in the year 2019, my lord, this honorable court passed an order asking them to produce the retrenchment orders, because all these years, although they were taking the plea, but orders were not surfacing. So they filed an additional affidavit in a IA, and thereby they brought the retrenchment orders on record. Thereafter, the writ petition was amended, and the amended writ petition, in the amended writ petition, the retrenchment orders have been put to challenge. Now, there was deliberations in between during the course of hearing at different spells of time, and a proposal was mooted whether that these three writ petitioners can be given the benefit of voluntary retirement scheme that was floated under them, or they can be regularized, or they can be absorbed in some other departments where their assets have gone. The respondent corporation has been dissolved, and the assets were distributed to some other corporations. Now, last time the affidavit that one affidavit has been filed by them, that was on 1st of June 2023, pursuant to an order of this honorable court, and they have taken a stand that nothing can be done now. So basically now the retrenchment order, which was passed in the case of the writ petitioners, that are under a test of this honorable court. Now, if your lordship finds that the retrenchment order is legal and valid, my lord, then the case ends. But otherwise, my submission would be that
So this matter will require final hearing.
yes,
You want it to be done today.
subject to your lordship's convenience, my lord.
We can start it, but it will not be concluded because there is just one day to go for this bench.
Yes.
And I'll not keep it parted. So you're most welcome to argue. Or you can choose a date after the vacation. Whatever suits you. Parted I'll not keep because I don't know the bench position after vacation.
But
And
if your
therefore, the
lordship,
matters will get stuck up. Therefore, no question of keeping anything parted now. Today and tomorrow are the 2 days this bench is available before vacation. Cannot keep the matters parted. That's the problem.
but if your lordship keeps it at past parted, it will only come to your.
But it may come next year.
No. My lord,
That possibility is there.
well, by last 6 months, sufficient indication is there that it will come before your lordship only.
You may be privy to some indication which we are not aware. So I can't.
No,
comment.
the bench composition, my lord.
I don't know. Nowadays, judges are hardly informed about bench composition. It is the bar which knows. So I don't know. You may be aware. Anyway, what is to be done today,
Well,
Mr.?
No, my lord, since she is also not present now, the CGSC.
Hmm.
So naturally, there is no point beginning the case now. If your lordship fixes it immediately on reopening, because the man is also very hard pressed.
Can you choose a date?
On 2026, sorry, on 25th of July.
Yes.
Lordship, Lordship.
But otherwise, it hinges on a very small point.
There is an order of retrenchment and they have in the affidavit admitted that the retrenchment benefits were not given.
But she's not around.
Yes.
That is the difficulty.
25th of July.
All right. But Mr. S. Bakul and his senior counsel assisted by Mr.
Yes, Chudhu.
Sobri, learned counsel appearing for the petitioners. Also heard Mr. A.R. Tahvildar,
Appearing on behalf of R. Devi.
who has appeared on behalf of Ms. R. Devi Lanis CGC and prays for and has prayed for some time in the matter on the ground that the learned CGC is not available at this point of time. Mr. A. Khanikar, A.R. Khanikar is present on behalf of the respondent numbers 2 and 3. Mr. Datta has expressed urgency in the matter by submitting that his clients have been retrenched and this matter pertains to the year 2016. As such, the writ petition calls for expeditious disposal. After taking note of the submissions and requests made at the bar and considering the nature of issue involved in this matter, registry is directed to list this matter again on 25th of July 2023 for admission hearing in the column as the first item in the column, disposal at the stage of admission. Unquote, as a fixed item. It is made clear that no prayer for adjournment whatsoever will be entertained in the matter on the next date fixed. So if there is any other matter, either alternative arrangements has to be made
Lordship.
or the CGC has to
I'll
seek
contact.
accommodation elsewhere.
Lordship.
We also need preparation to
Lordship.
hear a matter and deliver a judgment.
Lordship.
It cannot be done randomly.
Lordship.
So
I will-
this matter will be heard on 25th.
I-
And judgment will possibly be delivered on that day.
Lordship.
Whether somebody is available, not available, we are not concerned.
I will.
Oblige.
Oblige, Lordship.
May it please lordship, in this case, lordship, I was directed to make the back wages, payment of the back wages within 6 months by order dated 14/2/2023. And 6 months is yet to be over and process is on, your lordship. So your lordship may kindly fix a date in the 3rd week of August. In the meantime, 6 months will
It
be
was
over.
supposed to be paid in 2 installments, not a single installment is paid, lordship.
You have not paid anything.
No, your lordship. This process is on, after 6 months, any date may be fixed, your lordship, entire payment would be made.
When is the 6 months expiring?
14th of
8,
August.
14/8/2023.
Mr. K.L. Gupta, learned counsel for the applicant, not applicant. you are-
Petitioner.
Mr.
And Sharma.
N. Sharma, learned counsel for the writ petitioner. Submits that the steps for compliance of the order dated 14/2/2023 passed in IA bracket C bracket 2 number 91989 of 2022 has already been initiated by his client and the entire amount due and payable shall be released within the period of 6 months as fixed by the order dated 14/2/2023, which would expire on 14/8/2023. Therefore, a prayer has been made to list this matter again on the expiry of 6 months from the date of the original order. Mr. K.L. Gupta, learned counsel for the respondents, is present and does not have any objection if the prayer is allowed. Similar is the stand of Mr. T.C. Chutia, learned additional senior government advocate Assam, appearing for the state. In view of the request made at the bar, registry is directed to list this matter again on 16th of August 2023 as a fixed item.
Item 15.
May it please your lordship. Lordship, this is a long pending matter. The petitioner before your lordship is a casual driver who was appointed as a driver in the Coal India in the year 1994. Lordship, since then he is working as a casual driver. In the year 2015, there was a settlement reach out between the responding authorities and the petitioner, whereby they had accepted that they will send a proposal, they will initiate a proposal for his regularization. Till now, there is not a single whisper about that.
Anything is there on record? Anything in writing?
Or yes, on your
Where is
lordship.
it? Yes.
Lordship, a copy of the memo, that settlement
memorandum of settlement arrived between the representative. It is at page number. Starts from page 31, Lordship. Effective portion is at page 32. Lordship, point 3, it says, it is agreed that since local management is not competent authority for taking any decision on regularization of the services of Sri Vibhas Chandra Das, casual driver, a proposal will be initiated immediately and his service can be regularized subject to the approval of the competent authority. Along with this, settlement, they have also promised that the wages of the casual employee will be increased. But till now, Lordship, even after rendering his services for more than 30 years, Lordship, he is getting roughly around rupees 550 per day, which comes around to 17,000 per month.
All right,
Lordship.
so if it is regularized, then you are automatically
Lordship,
getting a
Lordship,
pay scale.
Lordship,
So
Lordship.
wages part does not
Lordship.
come into play.
Worship, this matter now, the problem is regularization, we cannot do it. Because the instructions from the ministry as well as the headquarters of Coal India, they instructed that no regularization should be done.
But
And-
he has been working since
In
1990.
spite of that, in spite of that,
Then we'll direct to pay him regular pay scale. Don't regularize him.
the regular pay also, Your Lordship, he is being paid, he's getting all the benefits as
No,
a
no.
regular employee. We've done that.
He is
Lordship,
getting-
I humbly,
Even a quota has been allotted to him.
No, what about the pay scale?
The pay scale he has not been granted. He is a casual labor. He's getting the same scale. And that, Your Lordship, Supreme Court has also agreed cannot be done.
No, but there are judgments of this court, Upen Das's case. Have you seen that?
Lordship, I hate to this.
No, what happens is that you see, people who have served for 30 years, 25 years, how can they be kept in casual roles?
Unfortunately, that has been accepted by Supreme Court has also said so.
In which judgment?
One by Justice Manohar Sapre, a recent one, 2019, 5 Supreme Court cases. Page 773. Copy that. needed.
What does it say? What is the legal issue?
In spite of they continuing for a long period, it cannot be regularized.
Cannot be regularized.
No,
Which is the paragraph? Have you seen this judgment, Mr.?
Lordship, I have not seen.
So then we have to pass a final judgment here.
Lordship,
This can't be an order. It has to be
Yes.
finally heard. Are you ready today?
Lordship, a date may be given after vacation.
no problem.
So which is the paragraph you want to show?
Paragraph
14.
14, by relying on Vartak Labor Union's case. That is a 2016. Paragraph 14, Your Lordship will see. Keeping in view the law laid down by this court in the Vartak Labor Union, when we examine the facts of the case at hand, we find that the facts of the case at hand and the one which were the subject matter in Vartak Labor Union are identical in all respects, except that the name of the trade union of the workers and the place of working in both the cases are different, which is hardly of any significance. The High Court, in our view, should have therefore examined the case in the light of the law laid down by this court in Vartak Labor Union rather than evolve its own separate scheme.
Acha, have you seen the judgment in Upendas, State of Assam versus Upendas?
Right now, huh?
Both of you go through it, because that is correct. Even this court has authored judgment that you cannot claim regularization as a matter of right. But To mold relief in Upenda's case, the court said that you have to pay them the minimum pay scale. And other facilities.
We'll examine that.
Please examine that. If you agree to that,
Lordship, I have one small submission. With,
make a big submission. Why small? Yes.
with all due respect to my respected senior, Lordship, my senior, respected senior has said that he is getting all the benefits, but this is not a fact, Lordship. Except for the quarter, he's not getting anything, no medical facilities, nothing.
We'll examine.
Lordship.
We have stated. Paragraph
Yes.
12 of our affidavit. That as regards the averments made in paragraph 19 of the petition, your humble answering deponent states that the petitioner is being provided with the basic amenities such as company quarter, medical OPD facilities, water supply, electricity, school facilities for the children, etc. Even though the petitioner
But the ML Kesri's judgment, have you seen it? ML
Lordship.
Kesri, you have not seen.
ML
ML Kesri.
case in no, Lordship, I have not
You
seen.
must do some reading, Mr.
Lordship,
What is your name?
Lordship,
Yeah,
PP
yeah.
Methi, Lordship,
PP Medi. Mr. Medi, you have to put in some hard work.
Lordship.
Nearly by asking, you're not asking it in the temple, you are asking it in
Lordship,
the
not-
court of law. So you have to do some hard work. You have to tell the court how
Lordship.
your case can be
Lordship.
treated differently. Otherwise, it is settled law. That matter of regularization, it is as per the government scheme. But in individual cases, if a person is serving against a sanctioned vacant post for long years, then arbitrarily he cannot be kept in regular, in casual employment.
Lordship.
Find out those judgments.
Lordship.
Mr. P.P. Medi, learned counsel has appeared for the rate petitioner. Also heard Mr. M.Z. Ahmed, learned senior counsel assisted by Mr. A.M. Datta, learned counsel representing the Coal India authorities. On the request of both the sides, this matter is directed to be posted for admission hearing again in the first week of August as a fixed item.
Thank you.
Obliging, Lordship.
Yes.
Lordship, in this matter, Lordship, Excedas is APR Lordship. Lordship, in this matter, Lordship may SCG, name of the SCGHC is not reflected in the clause list, Lordship.
Name of,
SCGHC Lordship,
what is that SCGS?
See, Guwahati High Court,
SC
my lord.
Guwahati,
Standing council Guwahati
Oh.
High Court.
in the respondent side, Lordship.
But you are present.
Yes, Lordship. Recently, I have informed them. Informed by them. Lordship may fix it after vacation. Otherwise, we are filed our affidavit. Lordship.
What is this matter about? What is this matter?
I'm ready to argue, my lord. What is this matter? Matter relating to the appointment of the computer assistants of the, as per selection made by the Guwahati High Court in the district of Gwalior.
Hmm.
In the year 2015, High Court has issued a notification for appointment of 397 computer assistants in different district of the world. Assam, AR marking 11 posts in the Gwalior district.
So he is saying standing council Guwahati High Court not shown in the cause list. So he is not ready today.
But maybe fixed.
All right, heard Mr. K. Sharma, learned counsel for the writ petitioner. Also heard Ms. M.D. Bora, learned government advocate Assam, and Mr. J.C. for respond numbers 3 and 4. Ms. M.D. Bora, government advocate Assam for respond number 1 and so forth. 3 and 4. It appears that the name of the learned standing council Guwahati High Court, that is the respond number 2, that is the council for the respond number 2, has not been shown in the cause list. As a result of which the council is not prepared with the brief today. In view of the above and on the request of learned counsel for the respond number 2, this matter is directed to be posted again in the first week of August 2023 by reflecting the name of learned SCGHC in the cause list.
May please. Lordship, matter pertains to release of the pensionary benefits. The matter is pending since 2018, but no affidavit has been filed yet. In the meantime, we made the necessary amendment by implementing
Abhayapuri Town Municipal Board and its chairman as party.
Lordship, I'll be appearing for the newly implemented party lordship 6 and 7.
Parties were implemented on 26/9/2020.
Yes.
But we have not received. no notice,
Why you are
Lordship.
not paying pension?
Lordship, no notice, but,
Hmm?
Lordship, actually, basically, Lordship, the fund is not available. This was what had been intimated to me, Lordship, on earlier occasion. But recently, this has been converted. Earlier, it was town committee, Lordship. Now it has become municipal board. And the new board is also functioning, Lordship. And I may be allowed to take instruction, Lordship, as I already have communicated to them
What is
yesterday.
the amount of pension? Are the people in the board who are working, your clients, they are getting their salary? Are they getting the
Getting
salary?
salary, Lordship.
Then how can you say fund is not available?
But I shall, Lordship, appraise your Lordship. Kindly list after the vacation, Lordship. Matter be listed.
You can't, you see, pension is a very sensitive matter.
Lordship,
You can't
that is-
get away with it by saying that
Lordship.
fund is not available.
I have already communicated to them, Lordship, on yesterday.
2018, 5
Lordship.
years. When did he retire?
2016, Lordship.
What is state of affairs?
28/2/2016, he retired.
All
He
right.
did an
But
excellent-
regarding CPF and all this Lordship, that time I have been informed that they were about to release this Lordship. Whether these things has been released or not, Lordship, that I am not aware of.
My
That's
instruction-
why I'm praying, Lordship, that kindly.
All right, you listen to the order. Heard Mr. S. N. Tamali, learned counsel appearing for the writ petitioner, also heard Miss S. Barua, learned government advocate Assam appearing for the respond numbers 2 and 5. Not for the state of Assam, is it?
What the urban development
Huh?
department. For one, P Nayak will appear. You did it.
Hmm.
Urban development.
2 and 3, Mr. P. Nayak, learned counsel has appeared for respond number 1. This is a matter where the petitioner has been compelled to approach this court due to non-payment of his pensionary dues. It appears that the petitioner had retired from service as an employee under the Abhayapur Municipal Board way back in the year 2016. Post of Miss M. Bhattacharjee, learned counsel appearing for the newly implemented respond numbers 6 and 7 submits that due to paucity of fund, the pension of the petitioner could not be released. She, however, seeks another 3 weeks' time to file affidavit on behalf of her client. First of, it must be noted herein that payment of pension is a very sensitive matter, and such a prayer cannot be brushed aside merely on the ground, merely on the plea that there is paucity of fund. Full stop. Therefore, the submission of Ms. Bhattacharjee prima facie appears to be completely unacceptable. On the face of it, be that as it may, in view of the request made by the learned counsel for the respond number 6 and 7, this matter is directed to be posted again on the 31st of July 2023 as a fixed item. The affidavit on behalf of respond number 6 and 7 shall be positively filed on or before 27th of July 2023 by serving advance copy upon the petitioner's counsel. If for any reason the affidavit is not brought on record on or before 27/7/2023, then in that event, the Chief Executive Officer of the Abhayapuri Municipal Board shall personally remain present before this court on the next date fixed. List this case again on 31/7/2000.
Lordship, this is basically not for pension, Lordship. Release of the arrear, that means retirement benefit, Lordship. This is not for pension,
Retirement benefits.
only retirement benefits,
So
Lordship.
pension, you change it by retirement benefit.
Item 19 and 20.
Deeply obliged.
Copy of this order will furnish to Ms. M. Bhattacharjee, learned counsel for the respond numbers 6 and 7.
My lord, in this case, my lord, this is first my lord, this is wrongly tagged with other matters, my lord.
Hmm.
Because the matter here contains, my lord.
What is this matter about?
Lordship, in the next case, we have filed our affidavit, Lordship.
Hmm.
All the appointments with Lordship, forged appointments, Lordship. There are no such Lordship process of a Lordship appointment, and these all appointments are forged appointments, Lordship. We have filed our affidavit in the.
But my case is not on that, my lord.
Hmm.
Because my case is, my lord, admittedly, my lord. My case, in this case, my lord, petitioner has already suffered a lot, my lord. They admitted, they said, my lord, they have been cheated by that. Now on the government has, my lord, annexure 2 and 3, my lord, I have annexed here with my lord. There is a scope of getting some consideration from the department. They submitted 2 representation there, my lord. The department neither dismissed nor accepted this represent. That's why only this case is, my lord. And they have challenged in the other petition, they have challenged probably, my lord, the appointment letter. We are not on that, my lord.
Where is your affidavit in this case?
Lordship,
In this case, they have not filed.
in the next case, Lordship, WBC number 42918,
Hmm.
we have filed our affidavit, Lordship.
When did you file it?
This affidavit was filed, Lordship, on March 18, Lordship.
There is no affidavit on record. Just check it once.
It is in the record, Lordship.
Item 20.
In fact, Lordship, similarly situated persons came before the Honorable Court, Lordship. This Honorable Court dismissed the petitions with cost, Lordship.
Yes. So this affidavit does not cover the issues in the
Yes.
other. You
Lordship.
mentioned it here.
Yes.
Have you stated that this is a common affidavit filed in the other?
Lordship,
cases?
it is probably not. Lordship.
Then we'll not treat it.
Then Lordship may take this matter separately, Lordship. In that case, Lordship, I have to file my affidavit in that case also. Yes.
Take down, heard Mr. So-and-so, counsel for the petitioner submits that the issue involved in the writ petition is completely different from that in WPC number 429/2018, and therefore these matters ought not to have been tagged together. Mr. N.N. Upadhyay, learned, Standing Council Irrigation Department, Assam submits that the departmental authorities have already filed an affidavit in the connected matter that is WPC number 4290/2018. However, if these two petitions are segregated and taken up separately, then he will be granted some time to file a separate affidavit in this matter as well.
Lordship.
Taking note of the submissions made at the bar, this writ petition is directed to be segregated from WPC number 429/2018 and listed separately after 6 weeks for admission. The respondents may file affidavit within 4 weeks from today by serving advance copy upon the petitioner's counsel. Extra copies have been.
Lordship, I have not received extra copy. Lordship, you will serve.
The petitioner's counsel to furnish extra copy to the learned department counsel. You are appearing for whom?
1 and 4.
Miss S. Borua, learned government advocate Assam, is present for respondent numbers 1 and 2. And what to do in this matter? You are there in this?
No, Lordship.
No, I am not.
Probably he will not appear, Lordship. The other, because Lordship, this case, they will not appear.
Achha. Take down. None appears for the petitioner on call. The petitioner's counsel was absent to WPC 429/2008 on the previous occasion as well. Mr. N.N. Have remained absent. more than two occasions, in more than two previous occasions as well. Mr. Ms. S. Burwal, learned Government Advocate Assam, and Mr. N. Upadhyay.
N. Upadhyay,
N.
Lordship.
Upadhyay, learned SC Irrigation Department are present. For ends of justice and in order to give one final opportunity to the petitioners to appear and argue the matter, this writ petition is directed to be posted for admission again after 6 weeks.
Lordship. Oblige. Oblige.
Your Lordship, in this matter, the engaged person, Mr. Esquire, due to some personal inconvenience, cannot appear for the.
Paid for by petitioners council, this matter stands adjourned for 4 weeks. Please take out.
In these cases, where we've received a communication from the chief secretary that he will file a comprehensive and common affidavit for all the cases and for all the departments. And he's already in touch with the DLCs, SLCs and other departments, when he requires 4 weeks time to file a affidavit. Thereafter, Lordship may kindly take up the matter.
This is item numbers 23 to
59.
59 and
One more tag in this morning.
98. Learned counsel for the respective petitioners are present. Mr. D. Majumdar, learned additional AG Assam, assisted by Mr. R. Dhar, learned standing counsel PWD Assam, and the other departmental councils are present on behalf of the respondents. Mr. Majumdar submits that in view of the issues identified by this court for a decision in this batch of writ petitions, the chief secretary of this government of Assam is required to file a comprehensive affidavit first of all. For the purpose of preparation of the affidavit, data is now being collected from various agencies, including the SLCs and the DLCs. As such, 6 weeks further time be granted for filing a comprehensive affidavit covering all these matters. First up, in support of his above submission, Mr. Dhar has produced a copy of the communication dated 19/6/2023. First up, having regard to the issue that has been identified in common issue that has been identified in this matters, I am inclined to grant time to the state to file a comprehensive affidavit facilitating disposal of all the writ petitions by a common order. The affidavit be filed on or before 11th of August.
My lord.
11th of August 2023 by serving advance copy upon the
To the
petitioners council. Registered to list these cases again as fixed items on 24th of August
My lord. Thursday.
2023 by reflecting the name of learned counsel for both the sides in the college.
My lord, item 30, I want to withdraw this petition as the petition appended on compulsion count, already appended. Item 30.
Item 30, you write, Mr.
Arvind Das, A. Das.
Mr. A. Das, learned counsel for the petitioner, submits that during the pendency of this writ petition, his client has already been appointed
On
compassionate ground, and therefore he has instructions to withdraw this writ petition. The prayer is not opposed by Mr. R. Dhar, learned additional senior government advocate Assam appearing for the state. In view of the above, this writ petition stands disposed of on withdrawal. Item 30.
Item number 62 is also same matter, my lord.
You want to
Compensatory
withdraw?
department.
You want to withdraw?
No, my lord, I think it will be.
62 also in the same bunch.
Same as like it's also compensatory. Otherwise, I have gone through it. Lordship.
Other court, we'll have it after vacation. Today time being is not possible.
Lordship, on last date, I filed my affidavit, Lordship. If they are not willing to file any reply, Lordship.
You want to file reply, rejoinder?
I'll have to take instruction, Lordship.
Miss So-and-so has appeared. Your name, please?
Q Kiba. Q Kiba.
Spelling.
Q Kiba has appeared for the petitioner. Mr. P Nayak, Learned Standing Council,
Finance.
Finance Department, Assam submits that he has filed the affidavit as directed by this court on
last date, Lordship. Last date. On 21/6.
on 21/6/2023 by serving copy upon the petitioner's counsel. Mr. T.C. Chutia, Learned Additional Senior Government Advocate, Assam, and Mr.
Thank you, Sharma, for respondent number 3, 4, and 5.
Sarma, Learned Standing Council, GHC, are present on behalf of the state. You have received copy of the,
Yes, sir.
Yes.
examine it, and if you want to file a rejoinder, file a rejoinder. And key cube multiply F Khan there. Mr. Khan submits that 2 weeks time be permitted to seek instruction on the affidavit filed by the department. In view of the above, let this matter be listed for admission again immediately after reopening of the summer vacations. The petitioner's counsel may in the meantime file rejoinder if so required.
Obligation.
Item 60.
May it please your lordship, we have filed our affidavit on 15/6, my lord.
Have you received affidavit?
I have both affidavit, one affidavit, but my lord, they have to clarify the status of the application they have submitted already. On that day, they told that they have submitted application and they want to know the status of this application. Otherwise, the paper is also already.
You have,
Lordship, the petitioner may file reply over affidavit, lordship. We have annexed our documents in the affidavit, my lord.
where is it?
Lordship, page, lordship, annexer 2, page 111, my lord. Of our affidavit, my lord. Running page 111, my lord. In fact, my lord, finance affidavit is necessary in this matter, my lord.
Yes, Lordship, in this affidavit,
The application they have referred to my lord, annexer 2 of their affidavit. In the letter, it was told that they have, the director have submitted a letter, a proposal for reconsideration of the matter. But the court was to know whether what are the status of the application, whether the application is disposed of or not. But on the other hand, case is very simple, my lord. The petitioners are qualified, they are entitled to get the regulation, they get the benefit. As well as be given to other.
Why are you not, there was a mistake by someone, then suddenly.
affidavit submitted by the Social Welfare Department, Lordship, it was returned. It was returned because proposals were coming repeatedly, Lordship.
But earlier, originally, they should have got it, but
Yes,
because of a mistake.
initially it was not submitted.
So
Lordship,
that-
I will file one, I take
So
instruction.
what is the way out? Then we'll have to go after the officers.
Yes, Lordship. Lordship, I think one affidavit is necessary on my behalf, Lordship.
See, it is not their fault, whatever has happened. Now, if the department throws mud against each other, then the High Court will have to enter into adjudication and catch hold of officers.
Lordship,
And that will be promoted by the state.
Lordship,
We'll
I
make-
have seen this affidavit today only, Lordship. I'll definitely take
we'll make it
instruction.
clear that this is what the state government is promoting now.
Lordship,
That in the blame game, the High Court should adjudicate. We'll get into it.
Lordship, I'll file.
No, my lord.
Yes, let him file. He wants to file an affidavit. Finance Department.
But it is known that.
Heard
there
Mr.
is- there is a move
C.
for-
Dekar, Learned Counsel for the petitioner. Also heard Ms. M.D. Bora, Learned Government Advocate Assam, who submits that a clarificatory affidavit on behalf of the respondent number 4 has been filed on 15/6/2023. I have perused the same. The issue raised in this writ petition cannot be adjudicated without the affidavit from the Finance Department. Mr. P. Nayak, Learned SC Finance, has assured this court that affidavit on behalf of the respondent number 3 shall also be brought on record within 2 weeks from today. As such, this writ petition is directed to be listed again on 31st of July 2023 as a fixed item. Affidavit on behalf of the respondent number 3 be positively filed on or before 26th of July 2023.
I'm praying for some more time, Lordship. I'll file after vacation.
After vacation, 31st July.
31st July, fixed person, 31st July.
July is not before vacation.
So I have to obtain instruction, then I will find out. In the month of August, not second.
My lord, only, they may be discharged.
Mr. Deka, we are trying to solve the problem.
Yes, my lord.
Just by saying, give me order, the court will not pass any order. We want to go into the root of the matter and give relief. You want an order, we are trying to give relief. So please wait. Let the affidavit come. On the basis of that, we'll pass some order. He has to be given time. He is a counsel. He has other cases also to handle.
But the petitioner said, may not be disturbed now presently.
They will not be disturbed.
No,
If
they will
if
not,
they are
yes.
given the benefit of it, they will get it from 2017 itself.
But
That
yes,
we are trying to get relief for your clients. You have to have patience.
yes, my lord.
Matter be listed again on, then you, instead of 31st July, you make it 9th of August. 9th of August. And the affidavit
Sir, I
will
got
be
this
filed
tomorrow.
on or before 4th of August. 9th August should be enough time.
Lordship.
It's enough, that's long time, my lord.
That's correct.
That's what even makes for.
That is correct, but that is why we are trying to find out what is the way forward. Nobody is rejecting your argument. All we are saying is have some patience.
So we did first week of August.
Next matter, please. Yes.
This matter related selection and appointment armed forces, my lord. This is covered case, my lord, judgment. All are reserved category, my lord, para 11, page 39. All are reserved.
Who is the counsel?
CGS.
Where is the order today? Some,
RDB appearing in this matter. I have to.
but she is appearing, but she is disappearing at the moment. What to do? We have to write
I will inform.
so and so disappearing in this case, not appearing. Where is Art Devi?
Yes, I will inform.
So it can be disposed of. How many petitioners
13 petitions.
belonging to OBC?
OBC and 2 ST, my lord, all reserved. Para 11, my lord, page 39.
18. Yes.
All reserved.
But now this will be subject to availability of vacancy.
Yes.
So many posts
Yesterday's
can, my lord, Home Minister also, my lord, in Rajya Sabha, my lord, declared, my lord, so many posts.
Yesterday's order will be. Please.
Disposed of.
All right.
Mr. HK Bush and Art Devi.
Maybe.
Yes.
And this is a compassionate appointment, your lordship. First time, my case was rejected only for underage, your lordship. Thereafter,
Underage.
yes, my lord.
Underage, my lord.
Thereafter, we sentence and we have division bench judgment, your lordship, order, your lordship. Thereafter, again, we have submitted.
Father died in 1990 on underage. How, what can be done now? Nothing can be done.
He only 4 months.
My lord, but there is a division, Supreme Court judgment, my lord. There, this, my case already covered this case, your lord. Kindly come on page number 67, your lordship. Khadim Hussain versus State of Bihar and others. 2006, 9 SSG 195, your lordship. Totally covered this case.
Which
My lord.
paragraph?
I have already produced the judgment, your lordship, in record.
I think so. But paragraph height is relevant. here also.
No, but in this case, first widow had applied within prescribed period.
Yes, my lord, my mother also applied for me lordship, on that time, your lordship, on due time, your lordship. My lord, it is a petitioner. First time applied 27/4/2015.
So there is no subsequent judgment. There are judgments.
The Santosh Kumar, he has annexed here as Santosh Kumar, my lord.
Hmm.
Lordship kindly see page 58. Santosh Kumar. Application for appointment regarding minor, second provided that the case of minor, application shall be made within a period of 1 year after attending majority. He attended the majority, my lord, where he applied 27/2015, he was in 20 years. 2 years after he applied. In this sort of case also not applicable. That's why I am saying, his date of birth, my lord, he here mentioned here 2 date of birth. One is 5/11, another is 1/1/1995. I think 1/1/95 is the date of birth is. That his age was 20 years, 26, 20 years, 3 months, 26 days. So Santosh Kumar case is also not applicable.
Santosh Kumar, which paragraph?
Page lordship policy 58 page.
What is the paragraph number?
Paragraph number 8.15.
8.5.
881. Application for appointment. Every dependent of a deceased government servant seeking appointment under this rule shall make an application within 1 year from the death of the
No, but
government.
that is because that was a scheme. What is
Scheme.
the provision OM in the Assam?
Yes, over 115, my lord. 16 to 1915.
What does it say? What does it say?
This says for within 1 year.
Where is the OM? Is it there?
OM, my lord, today is not available. And lordship Kalisi provided is there, my lord, Santosh case.
Hmm.
So he, after attending majority, within 1 year, he have to apply.
That is correct. Santosh Kumar's case will not be applicable here.
Not
because
applicable.
That was under some other OM.
Where?
What is the OM in Assam?
OM is something, my lord, again.
But my lord, division bench order, your lordship, page number 37.
Unless you tell me what is this scheme,
Paragraph-
I'm not going into anything else. If there is a
In
scheme,
this case, when first time I was applied, though my age was 4 years old, your
so
lordship,
and so for the
but-
petitioner, so and so for the respondent from the requesting learned counsel for both the sides. This matter stands adjourned for 4 weeks, so as to enable them to examine the legal issue, further examine the legal issues and address this court. You give me the OM. If the OM is not there, no order will be passed in your case. Next matter.
Obviously.
You have to see first what is the OM about minor.
OM is here, your lordship.
Oh, you did not place it. Do it after 4 weeks now.
Mass obligation.
Your Lordship, the counsel for respondent number 4, Mr. D. Majumdar and Ms. M. Bhattacharjee, they are currently on legs. However, on their behalf, I would like to place it on record that we got the affidavit in reply through our clerk yesterday late in the evening after 6 p.m. So require some time to go through the same. So you may kindly grant us some time.
I'm sorry, that's not possible. You have
2
to
days
give
of
me-
time may be granted, Your
No,
Lordship.
no, no, no.
Manu, it was filed on 22nd, Manu.
However, we received it yesterday after 6 p.m., Your
That
Lordship.
is their problem, Manu. We served it. on
Through our clerk, Your
22nd.
Lordship.
Actually, you filed your reply.
Reply.
But
And my lord need not even go into those things. It is that Golpara municipal matter, my lord, wherein behind his back, everything was done, my lord. So my lord wanted the answer.
Call them. You please wait. Call your seniors and take up this matter. Call Mr. Majumdar. Yes.
Item 64, madam may be adjunct to did not contain.
See, I appear for the rest number 1, Your Lordship. He has already retired from service, Your Lordship, in 2019 itself.
What is the relief?
It's regarding compassion appointment, Your Lordship. Compassion appointment.
Compassionate appointment.
Yes, Your Lordship.
That person who was seeking compassionate appointment, he is retired.
No, the officer concerned, Your Lordship. Respond number 1.
Then you have to file impleadment.
Lordship.
Heard Miss So and so for the petitioner, Mr. A. Das, learned counsel for the respond number
1, Your Lordship.
to submit that the respond number 1 in this case has already retired from
Yes, Your
service. Mr. N. Sharma, learned counsel appears for respond number 5.
He has also retired.
Huh?
He has also retired.
And submits that even his client has retired from service. On the request of Miss, your name please?
S.A. Khalifa. S.A. Khalifa.
S.A.
Khalifa.
Khalifa. This matter stands adjourned for 4 weeks so as to enable her to obtain instruction and file appropriate application for impleadment.
Much obliged, Your Lordship.
After demanding compliance of the order of this.
Obliged, Your Lordship.
For motion, item 86, 87, 88, 93, 94, 95, and 97.
May I please your lordship, in item number 86 to 88 lordship, arguing counsel Mr. H.K. Das is on legs lordship. Lordship may kindly matter may pass over for time being lordship. 86 to 88 lordship.
Yes, what do you say, Mr.? All right, we'll take it up after some time. Mine. At maybe 12:45. Mine. Yes.
Lordship.
My lord, the non-compliance of the order, my lord, operative part at page 24, my lord. My appearance has already been completed, my lord. Page 24, they need to have complied with.
Where is the order?
Page 24 is the operative part.
Yes, we are appearing.
4 weeks time may be granted. We'll get the instructions.
This is 2023 matter. We'll get last chance. Heard Mr. J. M. Gabriel and counsel for the petitioner also heard Ms. M. Khalifa, learned counsel representing the respond numbers 1 and 2,
1 and 2, your lordship.
who seeks 4 weeks further time as last opportunity to obtain instruction in file affidavit. They are allowed as one last time. Let this matter be listed again after 4 weeks. They are allowed so as to give one last chance.
Date may be fixed, my lord, if possible.
After 4 weeks.
Item 66.
My name is shown in the review petitioner side, but I am not for the petitioner. The fact is that,
So they say that wrong submission was made by
No,
the
my-
council.
he himself was present on the day. Your lordship kindly see the order. See the order dated 22nd, 2027. The Mr. K. R. Padgiri learned counsel for the appellant present and Mr. K. Sharma was also present. So he was also present on the day. And the brief has already taken from me by the concerned advocate. That is, we are annexing, they are annexing here with. And after taking away the brief, we are asked to not to place the case, my lord. That is why I did it. But he himself was present on the day. He could have told them that after me, he was engaged, I should not pay for dismissal. But instead of making any submission, allegation has been brought against me in the petition, my lord.
What is the relief sought for?
The petitioner dismissed from service, my lord. And rule already issued, my lord. And fixed the matter for hearing, my lord. I seeking, my lord, for early hearing, my lord.
So you were present for the applicant.
But due to some, my lord, interaction, my lord, it was.
We'll grant him.
Regarding review petition, I have nothing to say, my lord.
Heard Mr.
But
K. R.
when he
Padgiri,
was
learned
present,
counsel
he should
for the
have told that day.
petitioner. Also heard Mr. R. K. D. Chaudhary, learned DSGI appearing for the respondents. In terms of the order dated 16/6/2023 passed by this court, Mr. K. Sharma is also present. First up, this review petition has been preferred against the order dated 27/3/2023 passed by this court in IA bracket civil bracket close oblique 494/2023 filed by the writ petitioner seeking early hearing of the matter. Full stop. However, taking note of the submission of Mr. Sharma, the writ petition as well as the IA was dismissed for non-persecution. Full stop. Mr. Patgiri submits that since the applicant has been dismissed from service, there was urgency in the matter requiring expeditious hearing of the writ petition. As such, there was no question of not pressing the writ petition. Full stop. Mr. Sharma, on the other hand, submits that while taking away the brief, his client had asked him not to press the matter. Full stop. After hearing, however, after hearing the arguments of all the of both the set of counsels for the petitioner, it appears that due to some communication gap, the writ petition was dismissed for non-persecution by the order dated 27/3/2023. In view of the above, if the order is not reviewed, the same would lead to miscarriage of justice for the petitioner. Full stop. I therefore find sufficient reasons to review the order dated 27/3/2023. The order is accordingly recalled. The writ petition is consequently restored to its original file and be listed in the appropriate column after the summer vacation. Review petition stands disposed.
May be directed to not to show my name in the column.
However, the name of Mr. K. Sharma shall not be shown as counsel for the writ petitioner in the cause list.
Obliged.
Item 67.
There was a direction, your lordship, at page 11, 12, your lordship is the page 12, your lordship, the operative part, your lordship is there. 6, para 6 and 7. Now, he is not getting it essentially, your lordship, his prayer in the writ petition was, your lordship, for getting DNS relief, which has not been given to him, your lordship, with his pension.
Sometime may be granted, your lordship.
No, but every case you have to pass an order, that's all. Let her have another 4 weeks. time.
Lordship.
Mr. S. Bhattakulala, the counsel is present for the petitioner on the request of Ms. M. Kalita, learned counsel appearing for the respondents. 4 weeks, respond number 1, 4 weeks further time is granted for obtaining instruction and filing affidavit. What about, how many respondents are there?
Your lordship, only your lordship. Divisional forest officer, since direction.
Respondent, sole respondent. List the matter accordingly. None appears for the petitioner when the matter is called up. In view of the above, this matter stands adjourned and shall now be listed after vacating.
Item 69.
Please, your lordship. Hello, this is regarding violation of the order dated 13/5/22.
Mr. P. Bharadwaj, notice, how many contempt, how many sole opposite party, 8 weeks.
Item 70.
Is T box, is it?
My lord, please, your lordship.
Application. How many respondents?
Sole respondent, my
Sole
lord.
respondent, 8 weeks. Notice to take steps.
Obliged. Item 71.
Sole respondent.
Two responses.
two respondents. Mr. Yasnath, 8 weeks, two respondents. Yes.
May I please your lordship? The matter has been listed for correction of a paragraph in the writ petition, which was inadvertently made by the advocate on record while drafting the writ petition. What had transpired, my lord, I have been newly engaged in this matter. But what I, after reading the brief, what I could make out is, it was a bona fide mistake on the part of the learned advocate, because two advertisement was published on the same date and in the same newspaper. So while drafting the writ petition, the other advertisement was taken into account, although the subject matter of challenge, which the notice is under assailed by the petitioner, is with regard to a second advertisement. I placed that newspaper, my lord, in the record for the, and also filed an additional affidavit in this regard, explaining the bona fide mistake.
So let him file an amended writ petition.
No, my lord, I have filed my affidavit of opposition, they got wiser, and then they want to correct it. I
Correct,
think, my
my
lord,
lord.
this is my lord, a defective writ petition, my lord.
Absolutely correct, my lord.
Once I have filed my counter, I have disclosed my defense.
Mr. Patwari, either they amend it or we grant them leave to file a fresh writ petition. Which do you want? These matters cannot be shut out on this technical grounds.
No, but the lordship will grant them the liberty, I don't think.
Let them file it. We'll see the matter on merit.
Yes, my lord, why
These things do happen, you know. Sometimes it happens.
happens, my lord.
So what to do? The court cannot be so mechanical in these matters.
No, but the other document will be there, that's why, my lord, probably they should withdraw and file a fresh.
That is up to him.
Right.
You are making him wiser now. Why
I
don't you withdraw and file? That's a better suggestion.
Obviously. And that will, that
With
will-
liberty to file a fresh.
Yes, my lord.
All right. Heard Mr.
Yes, Das.
Yes, Das learned counsel appearing for the applicant. Also heard Mr. J. Patwari, learned. You are appearing from Mr. Patwari?
I am appearing for respondent number, private respondent number 4, 6, and 7.
Private respondent numbers 4, 6, and 7. Mr.
I am
J. I.
5 and
Bodhi,
8. 5 and 8.
learned counsel is present for respondent numbers 5 and 8. Mr. J.K. Goswami, government advocate Assam has appeared for the official respondents. This IA has been filed with a prayer to amend the writ petition by rectifying an error in projecting the date of the skill test, which was held on 15/6/2021, but has been wrongly mentioned in the writ petition as 11/11/2020. Wrongly mentioned in para 7 of the writ petition as 11/11/2020. The applicant has also sought leave of this court to replace the corresponding annexure, being annexure 9, with the call letter of the skill test held on 15/6/2021. Full stop. While a prayer for amendment of the writ petition may be permitted by the court on sufficient grounds having been shown, it is doubtful as to whether replacement of a document can be permitted on such an application. Mr. Patwari submits that the prayer has come after his clients had filed counter affidavit. Full stop. However, in his usual fairness, Mr. Patwari submits that if the writ petitioners want to withdraw the writ petition with liberty to file afresh, he would not object to such a prayer. Similar is the stand of Mr. J. I. Borguya as well as Mr. J. K. Goswami, learned government advocate Assam. In view of the above, without commenting on the merit of the prayer made in the IA, the applicant is permitted to withdraw the writ petition bearing number 7062/2022 with liberty to file afresh. After making the aforesaid rectifications, it is made clear that save and accept what is projected in this IA. The petitioner shall not be permitted to take any other new plea in the writ petition. He will file afresh. You can't take any other plea.
My lord,
Yes.
absolutely not. My lord, only one indulgence, my lord. I have also filed an additional affidavit to bring on some additional documents that may be.
Save and accept incorporating those facts and documents as have been projected in the additional affidavit already filed by the petitioner. First up, with the above observation, the IA stands disposed of. And next you write, in view of the order dated so and so, passed in IA number so and so, this writ petition stands disposed of on withdrawal with liberty to file afresh in terms of the leave granted by the order dated so and so, that is today's orders, passed in IE C 1375 of 2023.
Deeply obliged.
Item 73.
This is an application for substitution my lord, of the petition, but expired in the meanwhile, my lord, by a legal yes.
Take down heard Mr. M. Dutta Learned Counsel for the applicant writ petitioner. It appears that the original petitioner, that is Sabir Ahmed, had expired on
My lord, 22/1/2023.
22/1/2023 during the pendency of this writ petition. As such, this IA has been filed with a prayer to substitute his legal heir. That is the applicant number
1, 2, and 3, my lord.
1, 2, and 3 in place of the original petitioner. Full stop. It appears that the applicant 1, 2, and 3 are the sole surviving, are the surviving legal heirs of the writ petitioner, and the application has been filed within time. Mr. S.C. Kyle, learned standing counsel appearing for the respondents, submits that he would have no objection if the prayer is allowed. In view of the above, the prayer for substitution stands allowed. The applicant numbers 1, 2, and 3 shall stand substituted in place of the original writ petitioner. The petitioner to file amended cause title within 3 weeks from today. IA stands disposed of.
Pending matter item 63.
May I please, my lord? My lord, the petitioner was, my lord, earlier dismissed from service in 2016. I made a challenge to that. The procedure was not correct, my lord. I made a challenge. This honorable court set aside that order of removal, and my lord directed them to consider, do the process de novo. Accordingly, my lord, it was directed to be completed in 6 months, be that as it may. They waited till the last moment, a show cause was issued to me. I replied to that show cause. Thereafter, being dissatisfied, they appointed an inquiry officer, who was the chief executive officer of the board. Thereafter, my lord, we were called for an inquiry and I was given a questionnaire. I answered to that questionnaire. Finally, my lord, an undated report was submitted. Therein, my lord, we find that the inquiry officer has examined various witnesses behind 4 numbers behind my back. He has even gone to an office of an witness who was in the board earlier. Now, my lord, ACS officer different. He went to his office and examined. Thereafter, my lord, that report was given to me. I assailed that report before this honorable court. Anyway, this honorable court said that they have to take a final decision. They have now taken a final decision. Basing on that report, my lord, I have been removed, dismissed from my services. I put that to challenge. From the inquiry report itself, it's found, my lord, that the inquiry was not carried out in the manner it's
Where
required.
is it stated that?
My lord would have that straight away, the inquiry report at page 67.
No, where is the statement that witnesses were examined behind your back?
Lordship, my lord, I'll show that from the appeal itself, my lord, in my writ petition also. But when I preferred an appeal, a representation against that, at
No,
page
we want
7,
to see statements in the
writ petition,
on
lordship,
evidence.
lordship.
Yeah.
My lord would have paragraph 9, my lord, at page.
Mm.
My lord would have page 14, para 15, my lord. That the petitioner, no. That the page 14, para 15, my lord. That the petitioner states that on the receipt of the second show cause notice, it is reflected from the purported inquiry report. The inquiry officer had on various dates between 28/11/22 and 8/12/22, examined 4 witnesses. The said examination of witnesses behind the petitioner's back without involving him in the process. Basing on the purported inquiry, the inquiry officer has submitted his undated inquiry report holding the charges framed against the petitioner to have been proved. The procedure adopted by the inquiry officer to conduct the inquiry in the procedure prescribed in the communication, and accordingly, the inquiry so conducted is vitiated and void ab initio. And this was replied to, my lord, in page para 15 of the affidavit filed by the boardman, by the chairman of the board. It's at page
Para 15 of the,
affidavit filed by the board, my lord, which starts at page 86, my lord.
and which is the relevant para?
My lord would have paragraph 15, my lord. 91, my lord. That with regard to the statements made in so and so, the answering begs to state that he had no role in the inquiry process and he was not in a position to reply the contentions. On admission, the petitioner stated that he was present on 28/11/22 before the, and on the same time, in paras 15, he has stated that the examination of the witnesses is.
So what is the allegation against the petitioner?
My lord, the allegation against the petitioner is that he had used unparliamentary words against the then chairman, vice chairman, and the executive officer. That my lord would find at page 40, my lord.
So therefore, ultimately, the relief you are seeking is setting aside the order.
Setting aside the inquiry, my lord, if required, if they want, my lord, they can proceed with.
You have the records, Mr. Majumdar?
And that it was held behind my back, that would be evident from page 68 of the writ petition.
But we have to. see the records.
Para 15, the allegation which my learned friend was alleging is absolutely vague.
So that's all right.
And
but-
my record, when concerned counsel is on legs in the other court.
So, Mr. Nair, we have to see the records, see the allegations, and if it's correct, set
The
aside
only
the
thing, my lord, the allegations stand. I'm not saying the allegations, my lord, is there. But the manner in which the inquiry was conducted, I'm on that, my lord. If my lord can only bear with me for page 68, my lord.
Oh, 68.
Of the writ petition.
Yes.
My lord would see the first
Mr.
paragraph.
Nair, you are free to argue, but this
I
matter
understand.
cannot be finally decided today.
Lordship.
We have to fix
Lordship,
it and
Lordship,
get the record and pass the
Lordship,
judgment.
Lordship.
If you succeed, we'll set aside direct reinstatement and also see if there is an element of violation of the court's order. Therefore, if
That
it is
has to
found,
be seen. If
then
my
we'll
lord,
have to
fine.
register a suo motu contempt case. and
Lordship, a contempt is already pending, my lord.
Contempt
is
has been filed.
already been.
Has it been listed today?
No.
Then let it be listed. Mr. UK Nair, Learned Senior Counsel, assisted by Mr. S.K. Das, has appeared for the petitioner and submits that this matter is ready as regards pleadings. However, the records of the inquiry proceeding will have to be perused by this court for a decision on the issues raised in the writ petition. Mr. D. Majumdar, Learned Senior Counsel, assisted by Ms. P.
P. Dasgupta.
Gupta has appeared for respondent number 4. And
No, man.
then
I'm for the board,
has appeared for the respondent number.
board, man.
The
Yes.
board is a respondent here.
Yes, man.
Respondent number 4.
Four, man. Yes.
4 and submits that the records are not readily available, but the same can be produced on a date fixed by this court. Mr. J.K. Goswami, learned government advocate Assam is present on behalf of respondent numbers 1, 2, and 3. In view of the above, registry to list this matter again as a fixed item on 20th of July, 27/2023 as a fixed item, along with contempt case number
784 of 22.
784 of 2022. On the next date fixed, the records pertaining to the inquiry proceeding in original shall be placed for inspection by this court.
My lord, only one prayer. my lord. I was earlier terminated on 26/8/2016. My lord, then I was reinstated, but I was directed to remain under suspension. So subsistence allowance for that period, they have themselves admitted in their affidavit an amount of rupees 18,75,656. But that has not been released to me. That has to be released, my lord.
And that will be released. We have, in the affidavit, we have made it clear that we'll pay.
Since Mr. Majumdar has assured this court that the subsistence allowance payable to the petitioner
Will be paid.
during the period of his suspension.
No,
the-
during the period of his earlier termination, my lord, that period. 26/8/2016.
There are two periods, instead of indicating all the lordship may say that area subsistence allowance.
Area subsistence allowance as payable to the petitioner will be released without any further delay.
My-
I do not, this court does not deem it appropriate to pass any further order on the issue at this stage. Should we have it on 27 rather than 20?
Lordship can- no issue.
27, 27. Because that way they will get more time. These things will all come up next day. We are having
Right,
a
sir. If
contempt
they
case.
pay up, my lord, at least he gets some succor.
27th of July, my lord.
Yes,
Simply that's a holiday or what?
No, July khula ase.
27th of July is a holiday.
No,
You are talking about Supreme Court, Mr.
in my calendar. All right.
You must be having Supreme Court calendar.
No, no.
Arunachal ka.
Arunachal. Okay, yes. Call the hearing matters. Call.
For hearing. Item 74, 75, 76, 77, and 78.
What are these cases?
Lordship, I have some instruction from the department.
What are these matters?
Your Lordship, the matter pertains to inter-se seniority
Hmm.
in the grade of forest rangers in the forest department. On the last occasion, Your Lordship had directed the forest department standing council to bring on record the ACF gradation list. It was my submission that there is no ACF gradation list.
So they say they are in the process of finalizing the
Yes.
gradation list, want to address the grievance of all categories of persons. And after the rules are finalized, they'll prepare the gradation list.
Yes, but the issues, Your Lordship, in the writ petition will not be catered to by framing of a gradation list. The reason being, Your Lordship would come to the fourth paragraph, the fifth line in the first paragraph of the instructions.
So what do you want? The matter should be
No,
heard
not
today.
now, not now, Your Lordship, but the issue remains. So Your Lordship will fix a date for the matter to be heard. Your Lordship, even if they fix the seniority list as per gradation list, as per the rules, the issues which have been raised in the writ petition, Your Lordship, they still survive. They still survive.
We'll adjourn it then.
Yes, Your Lordship will fix a date for that matter.
But these are very old matters.
Next
already.
matter, Your Lordship.
No, why don't they complete the process and thereafter prepare a gradation list?
The
We'll
reason
give you
being-
liberty to come approach if you are aggrieved.
No, in fact, the prime submission in the matter is
Hmm.
that the APAC conducted an advertisement for 18 posts. There were 18 selected candidates. They were deputed in various subdivisions of the state of Assam. Thereafter, pursuant to a parallel process not sanctioned by the APAC, which is on record in the writ petition, the private respondents entered the service. And the first instance of they having gained.
All right, I
Yes.
heard Mr. M. Sharma, Learned Counsel, hearing for the petitioners in this batch of writ petitions.
Yes.
Also heard Mr. R. Gogoi, Learned Standing Counsel, Forest Department or something. Miss R. Kakoti, Learned Counsel, has appeared for the private respondents. These matters were fixed today for the Learned Departmental Counsel to obtain instruction. When these writ petitions were called up, Mr. Gogoi has produced a copy of the communication dated 13/6/2023, issued by the departmental secretary, a perusal of which goes to show that the service rules are presently under preparation and is likely to be finalized very soon, full stop. The Learned Departmental Council submits that as soon as the service rule is finalized, the grievance of all affected persons will be looked into and an attempt will be made to redress the same. As such, hearing of these matters be adjourned for 8 weeks. Full stop. Although these are very old matters, yet considering these are old matters, yet considering the nature of issues arising for decision in this batch of writ petition and the proposal made by the department, this court is of the opinion that some time should be granted to the department so as to properly examine the issues. As such, by retaining, hearing of these matters stand adjourned for 8 weeks. Copy of the communication dated 13/6/2023 be retained in the record of this case.
Item 79.
Please, regarding to promotion to the grade 4 to grade 3 post. The petitioner initially appointed as a grade 4 employee since 1992. And till that he is serving as a grade 4.
Which department?
Under PWD. And I have annexure 7, page 23. Stated that he is not eligible for the promotion to the post of sectional assistant. Despite the petitioner has been serving as a section assistant since long, though he was a grade 4 as insert.
Yes, he's serving in grade 4 post since 1992, Mr. Dhar. His grievances is not considered for regular promotion to post of section assistant.
My lord, today some difficulty, my lord. We could not trace the file. It's a very old matter, my lord. We'll have to reconstruct the file. That is the problem, my lord.
After vacation, then.
After vacation, my lord.
Mr. Chair, Patgari Learned Council is present for the petitioner on the request of Mr. R. Dhar, Learned SCPWD. He submits that the file is misplaced in the office. This matter is directed to be listed again for hearing after the reopening of the summer vacation.
Date may be fixed, my lord.
No, date is a problem. So many matters are coming. No food date will be given. Yes, yes.
May I please your lordship? Lordship, the matter here pertains to selection and appointment of Gawbura lordship. In this petition, will challenge the selection of the private respondent as Gawbura lordship. Lordship, due to the non-following of executive instruction, lordship, that is our main ground of challenge, and pendency of inquiry, lordship, criminal proceeding, that is another ground. Lordship will find our advertisement at page 16, lordship. 16 is the advertisement, Lordship.
All right, we'll do it in the second half at 2.
The
There are some other matters.
issue has
specific to-
already been decided by this honorable court, my lord, as well as the division bench, my lord, that the selection and appointment of Gambura cannot be challenged before the High Court without preferring an appeal before the my lord, commissioner. My lord, my appointment
We'll
has.
pass that order at 2.
My lord,
Lordship, I take after vacation, I have to look through the order, Lordship, that thing, Lordship, I have to look.
Since 2015, my lord, my appointment has been stayed, my
I
lord.
have to prepare, Lordship.
At 2.
My lord.
Yes. Yes, call the APSC matters.
Item 86, 87, 88, 93, 94, 95, and 97.
May please, your lordship. But your lordship is aware.
All may be taken up individually, but our facts are all different. So that's why I'm admitting that your lordship can take up one by one, my lord.
No, your lordship was aware that these matters, initially there was a writ petition, combined writ petition. My lord, these persons, they filed a combined writ petition. At that point of time, they were unaware of the reasons for what ground, on what ground their name was not there or their roll number was not there in the declaration of results. And thereafter, they have filed affidavit. They raised the objection that different cause of action is there. And thereafter, we have filed the 3 writ petitions on 3 covering 3 grounds of rejection. Number 1, cutoff. The petitioners who failed to get the cutoff marks in GS1 paper, petitioners who did not get the qualifying marks in GS2 papers, and third is the petitioners who did not darken the bubble in the OMR. These are the 3 primary reasons why their candidature was not considered. Now, before I take your lordships to the questions, now we are concerned with there is an issue which in the earlier round of litigation also I argued before your lordships. There is a claim mark and there is a mark given by the APSC. Claim marks are those marks which we are claiming that
Okay,
we.
Mr. Das, if not typewritten, can you at least give me a handwritten chart on what is the issue in which writ petition? What is it? Because as you say, the facts are different.
If I take your lordship, I have given everything segregated. If individual writ petitions your lordships take up, in fact, I have quoted the questions also. It will help, the petition itself will help your lordship. Otherwise,
Now, what happens is, if I don't pass the order today, I'll pass it after vacation.
No, your
Therefore,
lordship-
you have a cause to worry
Yes, I understand.
because this bench is not available.
I understand.
So the simpler format you give it, it will be better. If an order is to be passed, it can be passed. We'll take up the matter today itself,
Lordship,
but
I'll give me.
maybe at 2, then you can come up with the chart. It will be easier for us to, Mr. Pathak.
Yes.
I will know what is the issue in which matter.
Yes.
We'll go one by one, but then it may not be possible to
Because, my
pass an
lord-
order before
Yes,
vacation.
Bill.
That may not be good for you. Because then I will go through the record and find out who is what is what.
Lord, my only anxiety is that 8th, 9th and 10th July are the dates of final examination. So in the.
You give me the chart, otherwise
yes,
you are
my lord,
getting nothing before 8, 9 and 10.
My lord, I'll
We'll
give the
just
chart.
hear the matter and reserve the order.
My lord, I'll give the chart.
Give it
I'll
at
give
2. At
Yes.
2, I'll give it.
Yes.
Give it at 2. We'll commence at 2 with this matter.
My-
Give a chart.
Yes.
We'll refer to that and go into each matter.
My-
What is the issue? You have to, I'm sorry, you have to do some work. during
It's
the
all right, my lord.
recess.
It's
But
absolutely
please do
fine. my
it.
lord.
If I cannot dictate the order in the court, you are not getting it before vacation.
Yes, my lord. Absolutely. We'll do it. my lord.
That's the problem. All right, call him. I'm rising now. We'll sit at 2 and continue. Yes, Mr.
My lord, we have for item number 82,
This matter, when immediately vacation lordship may fix.
No date will be given.
My
because
lord,
it's creating
immediately after
problem.
vacation, my lord may indicate.
On
If
the
the purpose.
request of Mr. B.K. Das, learned counsel for the petitioner, as well as Mr. R.K.D. Chaudhary, let this matter be listed for hearing on a non-miscellaneous day after the reopening of the summer vacation.
Obvious.
Yes,
My number is 85.
yes.
Is it possible for us to?
You Can't say, can't say. You can't say. What to do? What do you want? You tell me. How long will it take?
1 at 5 minutes.
5 minutes?
Yes,
I'll give you 5 minutes, otherwise after vacation.
yes.
5 minutes in the second half. Second half, I'm in the middle of other matters.
Okay,
We'll do that for-
at 2 o'clock, I'm going to fix matter with this
Then
Michael.
can't
Then
help it.
my 31st of August, can the date be given?
Yes, yes, yes,
If it's possible, my lord.
yes. Mr. You're Mr. Tapas Das.
Yes,
Mr.
ma'am.
Tapas Das, learned counsel for the petitioner submits that in the second half today, he has another matter fixed before another court. And therefore, hearing of this matter be adjourned till 31st of August 2023. The prayer is not opposed by Mr.
In fact,
RKD.
Lordship, Mr. Parasar appears, his wife has got some medical problem, he's not present.
He told me also.
Submits that the learned CGC appearing in this matter is also unavailable today due to some medical emergency. In view of the above and on the request of Mr. Das, let this matter be listed for hearing again on 31st of August.
Yes, ma'am.
2020.
Can it be a parted matter? Is it possible for
No, no,
that?
no, it will come.
Deeply obliged, my lord.
Anything else? We'll see that too and continue with the other matter. What is your case?
Lordship, item number 84, in that case.
I
Lordship,
appear
we
for the petitioners.
What is the
we are
matter?
supposed to give.
My lord, the matter relates to my lord, service benefits that has been denied to the petitioner since long, since 89 in fact, including subsistence allowance. But records were called for a number of times, my lord, then records came, the cases couldn't be taken up, and when the cases reached thereafter on other occasions, the records became untraceable. So that was their submission before the court on today is the third occasion. So now I have been
Should they
told by my
collecting
friend that they are
documents?
trying to reconstruct the records. So that is
We
what.
are
Two
collecting.
parts of record, one from the government in the health department, I have got it, but the record from the Karbi Anglong Autonomous Council, that is important, my lord. Regarding the joining of the petitioner in that particular post
There was DP against him and then.
or unauthorized absence, my lord. So the allegation was that he joined there and he did not resume his duty, just joined and came there. So that's why that record is important, my lord.
So what is to be done today?
Well,
Lordship, can it be taken up after vacation, Lordship, by that?
after vacation, it can always be, my anxiety is mine, my lord. But if they're reconstructing, that's what I have been told, my lord, by her just now, my lord, the record. Okay, my lord, let it come after on a fixed date, my lord. That much I can pray for.
Mr. B.D. Goswami, learned counsel for the petitioner is present. Ms. S. Kemprai, learned standing counsel KAC
Lordship.
submits that the records available with the autonomous council had gone missing, as a result of which the same is in the process of being reconstructed. Under the circumstances, a prayer for adjournment of the hearing of this writ petition has been made by Ms. Kemprai with a request to post the matter again after the summer vacation. Mr. D.P. Bora, learned standing counsel,
Health and
Health
Family.
and Family Welfare Department, Assam, submits that the part of the records maintained by the state of Assam is available, but this matter cannot be decided without the records being produced by the Karbi Anglong Autonomous Council. Here for whom?
Lordship, I'm waiting for respondent number 9, accountant general,
Mr.
D. Rava.
D. Rava is present on behalf of the respondent 9. Taking note of the submissions made at the bar, hearing of these matters stands adjourned till 17th of August 2023. So as to enable the Nanit Standing Council KAC to produce the records. 17th of August.
Well, a little bit
No,
earlier.
no, that's all right. 17th. Before that, I need less. It'll go to October. For that, they'll again ask for time and they'll go to October.
They have already asked for the.
Yes, yes,
reasons.
all right. Can't help it. What to do in these matters? You can't hold a gun. I understand there are
Madam,
issues.
I have been deprived from 89. Man. My
Can't
case is
help
that.
it. You have tolerated since 89, tolerate. What is the issue in 86?
issue in 86 is, my lord, questions, answer key in GS1 paper, my lord. 86 no only missing.
It is GS1.
Yes.
So in item 86, you have challenged some answers,
Yes, my lord.
which according to you were wrong.
Yes, my lord.
Your client had given the right answers.
No.
Then
My issue is, my lord, in question number, say for example, question number 80 series A. My issue is the question itself is wrong. The giving of correct answer, wrong answer doesn't arise at all, my lord. It is the responsibility of the APSC to provide correct questions to the students. They say, who among the following was the first Assamese to contest presidential election in 1952 against Dr. Rajendra Prasad? These ABCD options, they were not there in 1952. I have annexed the Election Commission, my lord, document. It says 1952, these options were not there. So they have admitted in the earlier round of litigation, they countered this question, my lord. They said 1952 should have been printed as 1957. That means the question is wrong. And
how many questions are like that?
My lord, in GS1 paper, that is item number 86, question number 80, series A, there are 3 questions, my lord. Question number 39 in series A and question number 68A. My lord, I have given there, my lord. I have given the corresponding questions of the other series also, because there are 4 set series, A, B, C, D. I have referred firstly the series A question, and in bracket, my lord, I have given the other question numbers in the other respective series. So far as if I take your lordships with question number 39A, find the correct chronology of the following Governor Generals of India. 4 options were given. My lord, the concept of.
All right, so let's take it that all the questions you have flagged, the 3
Yes.
questions, the questions are wrong.
Lordship.
So therefore, 1 mark each is to be given.
My lord, 2 mark.
2 mark each.
Yes.
But this 2 mark will be given not only to you, but also the people who have already cleared.
Subject to correction, my lord. My lord, after the final answer key are declared, my lord, there is no occasion for giving marks who have already cleared. They have already cleared. My lord, this is a qualifying examination to the mains. It is not an examination wherein, my lord, if I score more marks, I will get more rank. While
But is there no cutoff mark?
there is a cutoff mark, my lord.
Then the cutoff mark will alter. Supposing, Mr. Das, supposing the cutoff was earlier 80 marks
Lordship.
and your client had scored 79.
Lordship.
Let us assume.
Yes.
Therefore, he or she could not make it. Now, say, let's say there are 2 questions which are wrong. So if 2 marks each for 2 questions are given to your client, then instead of 79, he or she will add 4 more marks and get 83. Correct. But the people who have made it, their scores will also go up now.
Lordship, there is another aspect also.
No,
Negative-
first let us deal with this aspect.
Yes.
If you agree with
It is
this
connected.
aspect.
It is connected to this aspect only, because there is negative marking also.
Hmm.
They cannot, my lord, do overhauling of the entire marks of the entire students
because there is negative marking also. If they correct these answers, someone will get negative marking now. 10,700 students have already gone, my lord. By getting marks, negative marks and my lord,
So
original
you are
marks.
saying that just
It
give me
cannot
the
be done.
marks and I come in and let me sit in the mains. That's the case.
That is my case, that if they want to give marks, they will confine marks to these petitioners only. They have approached this honorable court. They cannot go overruling of the entire process, 10,700 students, they will give 2
Why do
marks.
you say? Why do you say so? They
Because,
cannot go.
they will give, suppose, my lord, suppose in this question number 80, they have changed this question, they have corrected this question. It's fine. All will get marked. In the other question, question number 39A, answer key is wrong. In that event, if the answer key is corrected, somebody has
So
picked
Mr.
it-
Das,
I'm
as
sorry.
you can understand, we are a little up against the time. I can hear the matter whole day and
Yes,
fix it for further hearing after
I
vacation.
understand.
But I don't want to do that. That will not be a proper thing for the court to do.
Yes.
Otherwise, you can go on arguing, I'll hear till 4:15
No, my lord.
and fix
I'll-
it again on reopening. That is one way of doing it.
Yes,
The other way of doing it is if we all agree with things which are clear and blatant
my-
and leave aside the rest.
Right.
The fact of the matter is there can be no order passed by the court by giving the benefit of wrong questions only to your petitioners. That order I can pass today so that you have other remedies. So you have to convince the court that if it is a case that some answer given by your client has been wrongly found to be incorrect and therefore marks not given, then certainly if that is the case or in any of the cases if this has happened, then that in the opinion of this court would prima facie opinion would stand in a different footing. Supposing a candidate has given a right answer and the authorities have wrongly denied mark to the candidate for that, then that mark can be added, and if that person comes within the net of cutoff mark, then straight away a mandamus can be given. Because to give a mandamus, the court has to be clear about the establishment of the legal right.
True.
But the argument that you are making, that by and large false, I'm making it clear to you so that you
My
can
lord.
address the
Yes,
issues.
yes.
Otherwise, you go on arguing and I
No,
go on
it's-
hearing, that doesn't
There
serve
is
any
no
purpose.
end to that.
That is, though prima facie a logical projection,
Yeah.
it will largely be in a field of hypothesis. Because the argument you are making will not only be good for you, but all the 10,700 candidates. Therefore, to pick up your client and give a benefit in the form of a writ by leaving aside others who are not even parties before this court, that would be a difficult matter, number one. Number two, we don't know tomorrow if somebody else gets affected in any manner. We don't know. Maybe you will say that nobody will get,
Yes.
but then that is not a presumption we can take. And this is an exercise which will open the entire process. Either everybody is to be given these additional marks, in which event nothing alters. You don't come in, the cutoff mark shifts. Or it has to be an exercise done on the basis of individuals' position. Where you said there are negative markings, people might have. Please understand the question.
Yes.
One is to give whole hog the benefit of 3 marks. Three questions, wrong answers. If that is given whole hog to everyone,
Cutoff.
then not only you, the people who have made it will also get it, and that will alter the cutoff mark. If you don't give it to others and give it to you selectively, then the question is, what is the principle on which the court passes that order?
Yes.
Because the people who are, then you have to implead everyone. The others will say that we should have got it. Negative marking argument may not hold much water, because the only way you can come in is by holding that every other facets, everybody is correct. The only problem is with these 3 questions. So if these 3 questions are taken out, in the sense that there is a
From the-
positive mark given to everyone in this thing. How does it change the overall scenario? That's the question I'm asking. Now, you are probably trying to canvas that give the benefit of 3 marks, but since it doesn't matter to those who have already cleared, don't bring them into the canvas. That will not be possible. That will not be possible.
My lord, that's
Because if you give the benefit, you have to give it to everyone. It is a whole hog approach. But
True.
that I agree. That I agree that if you can show me that this aspect can be handled, I'm ready to pass an order to send the matter to an expert to take an opinion. And if you succeed, relief can be granted. Yes, that is an acceptable principle. But then you have to show me that what difference it will make, because it'll just take the cutoff mark a layer higher.
True.
If earlier it was 79, now it will be 83. Beyond that, what will happen? So if that aspect of the matter is not clear, what will be the outcome of this entire exercise?
my lord,
So I'm putting it to you so
Hmm.
that as a benefit of being a young, enterprising, good lawyer, both of you, all of you, in fact, you should not feel that our communication did not register with the
no,
judge.
no, on this.
And you should not feel that just because there is a time constraint, the issues were not properly debated. But if you can address the court on that, I am willing to consider your prayer. To send it to an
Yes.
expert, and if his opinion is positive, then we'll direct the APSC. But this is the supervening obstacle that your clients have. Insofar as the cases where wrong question is the issue.
Yes,
That is maybe item 86 and then
in item 86 only.
only item 86.
Other items, my lord?
That is a prayer in 93, 95 and 97 also.
Achha, 93,
95 and 97.
95 and 97. So in all these 4 writ petitions, the ground is common, that there were 3 wrong questions, not wrong answers, wrong questions. And therefore, instead of denying marks to the petitioners for the options exercised, they should have been given marks because the question itself is defective. That's the argument.
That's the argument.
But that is the argument which applies whole hog for everybody, as I pointed out.
True, my lord.
Achha, then what is the other issue in the other matters?
My lord,
I'll clarify one thing in that case, my lord.
Yes.
one question is,
In some of the petitioner, my lord, they've given correct answer. Now they came before this honorable court. No. So, my lord, there is a contradiction between them also. If you go by, my lord, some of the, my lord, I'll come to that, my lord. They, my lord, put a correct answer. Now, my lord, as a whole lot, they come to the court that, my lord,
No,
there is wrong.
Mr. Mahanta, see, I understand and appreciate. We are on a slightly different tangent now.
My lord,
I am trying to test their basic argument.
my lord.
If that test, if they qualify, then we'll go into the nitty-gritties by breaking down.
My-
At the moment, their basic argument is that you have set some wrong questions.
My lord.
Therefore, regardless of whatever answer they've given, you ought to have given them benefit of these wrong questions by giving them the full marks, 2 marks.
Fine.
So 2 into 3, 6 marks. If they get 6 marks, their overall tally will go up.
Understand?
But they will have to say why it will not go up for the other candidates also
Exactly.
who have passed. And therefore, the cutoff mark may physically vary, but it will vary proportionately for everybody.
Exactly.
If they succeed in that argument, then only we'll go break down into who is right, who is wrong. Otherwise, there is no question of going. And which are the other writ petitions numbers? Minus 86, 93, 95 and 97.
Yes, other writ petition is, my lord, WBC 3647/2023. This is with regard to GS2 paper, my lord.
No, can you give me the item numbers, please?
Yeah, item number
87.
87, my lord.
Item 87.
Yes,
Achha, this is pertinent. What is the issue here?
here also.
You are
my
the
lord-
counsel.
Yes, my lord.
You are the counsel.
Answer keys are wrong, my lord. Here, 3 questions. I have given in, my lord, that written note.
Okay, so
Here,
the
each
answer
question-
you have given
Yes,
was correct according to you. But because the answer key was wrong, it has been wrongly wrongly marked and marks have been denied to you. Is that your case in item 87?
No, not in all cases, my lord. Some of the petitioners, they given the correct answer. Here, my lord, if your lordships kindly take that written note, my lord.
Achha, 87 has a number of petitioners.
Three petitioners, my lord.
Some has given.
Some did not attempt, some did not give the correct, tick the correct option. Some has ticked the correct option. So it's a
You
mixture
have
of the-
again filed a joint petition despite having been pointed out last time.
But it will not be so difficult, my lord.
Let's see, let's wait. and
Yes,
see.
my lord. I'll just
When
try.
the judgment comes, we will see what is the difficulty.
Lordship will kindly if take question number 11, series A, in that write-up, my lord.
Yes.
They gave a passage in their question. That passage your lordship will find in, lordship will have to take the trouble of taking the
Yes.
repetition,
Yes, please.
page 73, my lord.
Yes, item 87. You are referring-
Item 87 I am referring to.
Yes. Please give item 87.
Page 77 is the question. Page 77 is the question they give. They gave a passage. May I read the passage, my lord?
Yes.
Mountains have always been held in great awe by mankind. They have been a challenge to humans. Those brave among us have always wanted to conquer them. You see, the more incredible the mountains, the greater the thrills, a challenge to the bravery of human race. Climbing mountains is an experience that is hard to put into words. Mountain climbing is undoubtedly one of the most popular adventure sports. Along with being challenging and risky for the climber, without any perceived risk, there cannot be a feeling that any significant challenge has been surmounted. The enthusiasts must develop in themselves the spirit of adventure, willingness to undertake hardship and risks, extraordinary power of perseverance, endurance, and keenness of purpose before climbing a mountain. Up there, where the intention is to embrace nature wonder, one realizes that it cannot be done without facing its formidable glory. A true mountaineer may challenge the mountain, yet is always respectful to the powerful forces of nature. Now, from this passage, they give the question 11, why does the writer say that mountains inspire awe in humans? APSC answer key is they present us with opportunities for exciting sports. And the source I am relying is that CBSE sample paper 4, my lord. This passage has been directly taken from CBSE sample paper 4 of 2022. There, my lord, the answer key given is, my lord, they evoke a wish in us to conquer them. Lord, this is not chemistry or biology, my lord. This is simple English. A passage has been given wherein things have been said about conquering the mountain.
Mr. Mahanta, you provisionally allow them to participate. We'll decide the matter.
I'll touch this petition. I'll make my submission, my lord.
No, what I'm saying is you make your submissions,
My lord.
but how many petitioners are there in total?
There are three petitioners. No, just for a moment, your lordship, can you take up this petition, my lord? Now, my lord, this is my compilation, my lord. Your lordship kindly see. They said this answer will be B. Assuming that is correct for a moment. But what he has given answer, my lord? Petitioner number 1, he option D. Even according to them, if it is corrected, they will not get marked. Petitioner number 1 get not marked. In question number 2, according to this three petitioner, answer is, my lord, A. Now, petitioner number 1 giving option B. So question number 2 is also according to them, my lord, he will not get anything. Petitioner number 3, in question number 3, petitioner number 1, according to them, now their correct answer is C, but he is given, my lord, A. So even when it is corrected according to their way, petitioner number 1 will not get any mark. Then, my lord, another thing, very important thing, my lord, petitioner number 3 giving a correct answer, he get mark. Now, my lord, if we accepted, my lord, their version, then he will get minus mark, my lord. So it is a contradiction among them, my lord. Suppose for a moment, as they are all the three petitioners says that these are the correct answer. All right, we accept it. Even then, my lord, petitioner number will not get anything, my lord. Because he already, my lord, given the other option, my lord. So if we go by their version, my lord, even then he will not get any benefit.
No, that's correct. The court is not rejecting your argument.
My lord.
What I'm saying is these things we'll have to apply our mind
My
into the
lord.
matter. So what will heavens
No,
fall
it
if
is
three
apparent,
persons
my
are,
lord. It is apparent, my lord.
if three persons are provisionally allowed to write the mains exam, what will be the problem?
Problem is that, my lord, tomorrow another candidate will come. They are
We'll
failed,
make
my
it
lord. They are
clear.
failed. They are not qualifying in the examination. Those who are not qualifying, how we can allow them to sit, my
Because
lord?
of a court order.
My
If the
lord.
court passes an order, you will have to do it.
Yes, court can pass,
Then-
but they will, my lord, prima facie, my lord, your lordship, even
So
there,
that
my lord,
is-
petition
that-
allowed,
that
my lord.
is all right.
Even right moment, if your lordship allow this petition, even right petition, they will not get marked, my lord. What I am submitting, my lord, if your lordship accept their version, my lord, three petitioner, they say that this should be this. Assuming, then also, my lord, petitioner number 1 will not get, and petitioner number 3 will get, my lord, minus.
That's all right. You tell us one thing. If they are provisional, these three petitioners, I'm talking about this writ petition. 3647. If the court ultimately passes an order to provisionally allow them to write the mains examination, what is the problem?
Problem, my
What
lord,
is the
then-
operational problem?
Then problem is that, my lord, already, my lord, another, my lord, candidate, because same situation of all, my lord, they are, tomorrow they will file a petition, my
So
lord.
that is the only problem.
That is the problem.
We'll make it clear that no further, this type of prayers will not be entertained. No other petition has been filed. As on today, any petition has been filed.
No, my lord.
Then we'll make it clear that this order will not create a precedent. This will not be applicable in case of any other applicants who might like to take advantage of this order
My lord.
by filing subsequent writ petitions. That part will clarify.
Then, my lord.
But in a hurried manner, these things, we have to pass a judgment.
No, my lord, this case, my lord, is apparent. Your lordship kindly, assuming petition allowed, his petition allowed, according to his, my lord, correction will be correct. Then, my lord, petitioner number 1 will not get anything, and petitioner number 2, 3 will, my lord, get minus mark. Because, my lord, what probably, your lordship,
Okay, so we'll pass an order in this case in the chamber. Let us argue in the other matter. The other cases 86, 93, 95, 97. Difficult. The cutoff mark will alter equivalently.
one thing I am being pointed out, my lord. When, my lord, provisional answer key was published, at that point of time, same day, my lord, there is a notification published in the website. Any complaint, if you want to make, will accept it. 1 week time was given, and they did not do anything. Then somebody has, my lord, some candidate, they file a petition. They have, my lord, accept, well, we send it to the, my lord, expert.
Mr. Pathak wants to say something.
My lord,
You don't have much time.
Petitioner item number 97, she has challenged the questions, your lordship, that is on.
I will come to that.
So that is it. On all these petitions, the question raised is that the question said by the APSC is wrong.
Yes, your lordship.
If that is accepted, then marks will have to be given to everyone.
Lordship, rather than giving the marks to everyone.
No,
lordship,
that
the
cannot
question
be.
itself,
that
questions themselves are cancelled, your lordship.
What the APSC do?
If it is cancelled, then it has to be done uniformly to everybody.
Milord, what
Then,
APSC
my
do subject to
final answer
correction,
is
Milord?
prepared.
Milord, what APSC do? They issued a notification. Lordship will remember they have given the cutoff mark and they have issued a notification. In that notification, they say the questions wherein there is no correct option, forget about the question to be wrong. Where there is no correct option, they give grace mark on pro rata basis. What I am trying to submit before your lordship is that now you cannot give pro rata because 10,700 has
That
already
argument we are
gone.
not.
That is what. But they gave grace mark to the candidate as per their own notification. So far as GS1 is concerned, my lord.
They may give less mark to.
Grace mark to all the candidates. Page
That is
150.
it. The grace mark means the mark for that question is given to all the
Milord,
candidates.
that is also ambiguous because what they say in
Oh,
that.
Mr. We'll hear it in 2024.
No, my lord, lordship will
All
kindly
these things you can't raise in the first day.
they give grace mark. They say, Milord, I just read number of question where marks given to all candidates as there was no correct option 2. 2 questions, they give marks to all candidates because there was no correct option.
Here we are saying is that your question is wrong. So where is the question of which option I take or?
So what is the, Mr. Das, I'm not going to ask you again. You are
I'm
now,
sorry, my lord, your lordship is
I am
saying-
just asking you same question. Whatever is to be done to you has to be done to everybody.
True, my lord.
That's the only point here. So
That
if
is
that
one-
is done uniformly, if it is applied, this does not alter
there
the,
are-
this does not alter the position in any manner.
Yes.
You get more mark, but then you remain in the same
At the
position.
same time, my lord, my negative mark that goes. If that goes, I come in, my lord. I come in. And apart from that, that is not the only one question. There are two more
That,
questions.
that exercise has to be done for everybody, all 10,700, which is not possible now. Which is
There
not-
are two more questions also, my lord. That also your lordship in this, in one, the answer key is wrong. Sorry, my lord, the question is wrong. In another, the answer key is wrong. Same like GS2, answer key wrong. Here also, my lord, one question wherein there is some mixture. There is some mixture. I know, my
Then
lord.
then we'll examine it in due course.
In
Beyond that-
GS1, lordship will kindly consider that if your lordships kindly take up my write-up that I given. For a moment, my lord.
See, the allegation that the answer is wrong is one thing. But the allegation that the question itself is wrong is another thing. If the question is wrong,
Yes,
if it is accepted,
yes.
uniform mark has to be given to everybody for that.
Fine, my lord.
And readjustment,
But
if it is done whole hog, then the situation doesn't change. If it is done on the basis of figuring out who else has made a negative answer, then it is not practicable.
True.
So that is the reason I am dismissing on item 86, 93, 95, 97. And in this item, 3643, the parameter is, since an allegation is made that the answers provided do not correctly project the options available for any of these questions. This matter would require deeper analysis, which will not be possible. They'll have to file their exam. So these three candidates will be provisionally allowed to write their mains exam. Their results will not be declared. And if we, after hearing their arguments, we find that there is no merit, matter ends there. It will not give you any right. And this order cannot be used as a precedent for by any other unsuccessful candidate to approach this court and get a similar order. This is what we are going to make it clear. This is the order I'll pass. You can take another 15 minutes to say whatever. you want.
I'll take less than that, my lord. My brother is referring to one more aspect, my lord. In question number 80, that is who is the presidential election. Not only the question, the answer key was also wrong because name was wrongly given. That my brother has indicated. My lord, apart from that, there is
Mr. Das, I didn't want to say this, but sometimes we apply your mind. If the allegation is answer key is, question is wrong, what is the answer key doesn't matter.
I
Don't even
understand.
argue.
I understand.
Don't even argue on that. This is
Yes.
simply wastage of time.
The entire thing.
You all
goes.
are growing councils. You must apply your mind. You need to
understand.
rise
Yes, my lord.
at a level.
Yes.
Be very precise, surgical strike.
Yes.
Once you said that the answer is wrong, matter is over. You have to come up with an uncut argument
Yes.
that if you accept this, this is the relief my client will be entitled to, an exclusive relief. If you can't make out that case in 5 minutes of your argument, it's over. The answer is, the question is wrong, but even the answer is wrong. A wrong question cannot have a right answer.
Lead to the same conclusion. I am.
What are you
my lord,
arguing?
For my brother's satisfaction, my lord, that lordship will kindly
no,
pardon me for that. But here also in GS one paper, my lord, there is one question. I'll have to say that before your lordships, my lord, with all humility.
Achha,
my
you
lord.
argue your matter. We'll hear him. We'll hear Mr. Pathak also.
Yes, my lord. Only one thing, my lord. Question number 68, page number 4 of the this writer.
No, you see, we appreciate
answer key is wrong.
some young aspirants are before the court.
Yes,
So the court is very concerned and sensitive,
I understand.
but we can't decide these matters emotionally.
True.
Every case, every legal aspect has its own space in time, place, practicalities. That is what is the essence of justice.
True, my lord.
While we are concerned about the aspirants, we cannot be oblivious about the issues facing the APSC as well. So therefore, you have to come up with the uncut argument that the court finds no option but to pass that direction. That argument is not forthcoming in item 86, 93.
86,
95.
perhaps Milord, I made a mistake by referring to this question 80 first. Perhaps I should have referred question number 68 first. Three options given, Milord. It was said which statement is correct. One statement, there are two bridges over river Brahmaputra. It's a correct statement. It was not qualified. There are only two bridges. Their provisional answer key was that statement is correct. They have changed that answer key in final. What I am saying is that, Milord, they have erroneously corrected the provisional answer key. That is my submission, Milord. Nothing more than that. They have erroneously corrected. A statement is given. There are two bridges over river Brahmaputra. That statement is on the face of it.
That is not correct.
That is
That is not correct.
three bridges are there,
Yes.
Milord.
So that is a wrong question.
It's not. It doesn't say only.
That's why.
Yes.
That's a wrong question. If the question is wrong, there can't be a right answer. What is the point in referring to?
I
A,
just
B,
leave
C,
it
and D?
to your lordship. These are my basic
All right,
principles.
all right.
In GS1.
Yes, Mr. Pathak.
One more issue is there regarding, Milord, darkening of the bubble in 88.
Yeah, we can't go into all these things. You see, there could be some mishaps.
Yes,
Can't help it. This happens in all kinds of examination.
yes.
We will only deal with which are judicially manageable, where an order can be passed on sound judicial principle.
True, Milord.
It may be the case that some hit could be happening. Somebody who's not darkened a ball might have got a benefit. We can't go into a surgical, microscopic postmortem of what has happened. On broad features on the legal principle, if it turns
True,
out
Milord.
that the
I
court
also
can pass an
understand.
order,
Yes,
because our orders become precedent,
Precedent.
Mr. Das, you have to understand
I
that.
understand.
The moment an order is passed, people will
Yes.
keep coming and saying that you pass an order in this case. Therefore, the judges will have to balance their views.
True.
We can't pass orders emotionally. You have the luxury of going whole hog. We don't. We have to keep in mind we have to balance equities. These are courts of
We'll have to,
equities.
lordship has to see
Correct.
everyone.
So therefore, after hearing the arguments, it must come from within that this order must be passed. If it
So far
doesn't
as
come,
GS2 is concerned, Milord, I am absolutely sure that there are materials. Milord.
so at the moment, as I've already mentioned,
Regarding
some interim relief in WPC 3643.
lordship.
Because here you are raising question about the
WBC
validity
Milord
of the answers.
3647. WBC 3647.
3647, is it?
Yes, Milord.
Item 87,
Item 87.
which is item 87? 3647.
Yes.
Yes. 3647, there are three petitioners, right?
Yes, Milord. There are three petitioners.
There is regarding that, my lord, bubbling, my lord. They say that is it not directory, it is directory, it is not mandatory. In that case, there is a Supreme Court judgment and it is already settled, my lord. The instruction given by the APSC is, my lord, that is.
All right,
that's
let him finish.
Just one prayer which I'll place for your lordship's consideration. Since I don't know the question regarding the presidential candidate, both the question and the answer are wrong. Some candidates have already got marks, but some candidates, your lordship, because the question is wrong, they have been negatively marked, your lordship. For example, item number 97, your lordship, she has fallen short by 0.5, your lordship. So if the negative marking is removed for all candidates, no marks need not be awarded, your lordship. If the negative marking is removed for the
What is the total number of past candidates?
My lord,
How many candidates have passed?
total appeared 75,000, now 10,000 passed, my lord, now call for one. Qualified 32,000. Now, my lord, 10,000 call for.
So, Mr. Pathak, we will ask them to send all records to you. You have to check the marks of all 10,000 candidates and find out who are the ones who should get the negative marking, who should not. How much time will you take? Can you give the report by 30th of June?
lordship, maybe that relief can be perhaps limited to the present petitioner because she has made the effort of coming for a lordship. That if the negative marking is removed for this petitioner only, your lordship, because she is the one who is taken the trouble of coming for a lordship, then she will be through at least because she has been negatively marked for attending that question, where the question and the answer are both wrong. I'm not
Correct.
pressing the others, it's only in her case, your lordship.
Negative, instead of negative, give her positive marks for this.
For that, your lordship, the entire exercise has to be conducted, everybody will have to be marked, your lordship. But if if the negative marking is removed from.
Which is your item? Your
Item number 90, I'm only pressing 97, your lordship. She has fallen short in GS1 by 0.5 of a mark. That 0.5, she has been negatively marked in that question, your lordship.
That's all.
Yes,
Yes.
I'm only pressing that one.
Partition, my lord, his petition is concerned, my lord,
Only 97.
97, so 97. So my suggestion before.
He
your
had
lord-
challenged this question also before the APSC.
In GS,
GS1.
and this, according to her, the answer is wrong.
Question and the question itself, she had challenged the answer also, your lordship, because that question could not have a right answer. Because we could only challenge the answer at that relevant point. If the question and the answer are both wrong, she had attempted the
So,
question.
but then she stands in the same footing as the other petitioners.
No,
Yes.
because your lordship, she has attempted that question and she has been negatively marked for it. The others have not.
Others have not.
Others have not, your lordship. She has attempted the question.
Petitioners in item 86, 93, 95 have
I am
not-
only speaking for my petitioners, your lordship, in item numbers 94 and 95, your lordship, they have not. 93 and I'll just give your lordship the petition numbers. The other two petitions, they have not challenged. They had not attempted. She had attempted the question and she has been marked wrongly. In item numbers 95, 93 and 95, they had not attempted.
And this item 94 is also part of this.
94 is a part because, but she is on a different footing. I'm not pressing it today. Perhaps there she's not bubbled the answer script OMRs properly. 96 is a separate petition. It's not connected to this series. At present, I'm only pressing on 97, your lordship.
All right. Yes, Mr.
My lord, in that case, my lord, he is given answer, my lord. He answered, there is no ambiguity, my lord. And on the basis of.
No, you only talk about item 97 and 87. Rest of the matters don't bother much.
Yes, my lord.
Only item 87 and 97.
87 and 90.
These are the two matters we are inclined to keep the matter open live for some more time.
My lord, that 97, my lord, your lordship kindly, that Samadhita Goswami, my lord, she answered that question, my lord, and giving wrong, my lord. Now she cannot say that it is a wrong, my lord, that answer is because that is accepted by my lord on the basis of the expert, my lord. We have examined and my lord given mark to my lord all 10,000, my lord. Now, my lord, if he's not attempted, my lord, they can question is there is ambiguity, but there is no ambiguity, my lord, because he has answered. She has given answered, my lord. They got wrong answer. So that is not that, my lord, he is not attempted, there is a ambiguity. Now he cannot question, my lord. So your lordship kindly accepted that version, my lord. And
So if the court decides to send the matter for opinion of an expert,
my lord,
who would be the expert?
my lord, on the basis of expert, we find answer, we publish the answer key, my lord.
No, the court wants to send it. Court wants to send it.
My lord.
Mr. Mohanto, the court is entitled to take it.
Exactly, I understand, my lord. Suppose, my lord, what will be the difficulty, my lord? I am submitting. Suppose, my lord, then now that expert will give a separate view, my lord. Then whole process will be, my lord.
That we will block by the order of the court. I have mentioned it already. We will not allow anything else to be reopened.
Man, that, my lord, it will become a precedent, my lord. Your lordship kindly, my lord.
That is your submission.
My lord, obviously, my lord, and you already, my lord, 38,570
What is the
attempted that question, my lord.
Total number of candidates who applied 75,000.
75,000.
And how many candidates attempted it?
Attempted 38,573.
Yes, attempted. And how many candidates cleared?
At 8,698, they have given correct answer.
And how many cleared in the prelims exam? How many
10,000?
candidates?
10,700. 10,000. Total. 10,000, exact figure I will give you, Lordship, my lord. Citation put it. 7,000. I will give the figure, my lord. $10,148, my lord. Total seat.
All right, now please, Mr. Mahanta, please tell us what is the principle to be followed. There are candidates who have come before the court saying that the FPSC had made a mistake in framing the question itself, not to speak about the answer. They are giving their version, you are giving your version. If
No,
the court finds,
Regarding my lord, your lordship kindly, whether we have given my lord wrong answer or wrong
no,
answer.
please understand the question.
My lord,
You are giving your version which you are entitled to.
my lord,
They are given their version which they are entitled to.
my lord,
Now, if the court wants to pass a judgment on it,
my lord,
we have to have solid reasons for doing that. Correct?
my lord,
We can't just arbitrarily choose your version because you are a PSC
my lord,
or choose their version because they are
my lord.
candidates. We need a basis to come to the conclusion that the argument made by such and such has some merit and therefore accepted or is rejected. Correct? That basis has to be an opinion of a court appointed expert.
In that case, my lord, I am submitting there is a honorable apex court judgment. If there is a, my lord, two view possible, then always view always goes to, my benefit goes to the examining body, my lord. That is the judgment passed by the apex court, my lord. Because experting body, my lord, but the court cannot go, my lord, it is already or expert has given it on the basis of the expert
So
opinion.
you are suggesting writ petitions should be dismissed.
No, that your lordship kindly see. Why? Because your lordship, it will become a precedent, my lord. Even also, my lord, in future also, it will be very difficult for us to run the, my lord. Entire, my lord, entire system. Suppose, my lord, the expert given an answer that these two consents are wrongs, then definitely, my lord, entire process will be really apart, my lord. That is my apprehension, my lord.
All right.
My lord, on with the judgment, your lordship kindly look into, my lord. I will pass the judgment, my lord. 2018 to SCC 357, my lord.
2018
to SCC. That is already given there, my lord. 357. The judgment is there, my lord.
Which paragraph are you referring to?
Para 30, my lord. Paragraph 30. It is a- Need to pause for a minute. If it's not, then take over time, which will be- Yeah.
Yes. What is the finding of the court?
Finding it, there are para 30, my lord. Para 30, my lord. It's got to give legal. Confirm the way I will do.
All right, yes.
Another judgment, my lord, 2018, 7 SCC, 254, my lord. Para 14 is very important. Para 14, my lord. It is totally covered with our case, my lord.
Para 14.
Para 14, my lord. Listen. Division. My lord, opinion of the expert is also, my lord, is applied to.
Nobody's, we are not directing opinion or expert.
No, already our opinion expert, my lord, that is before your lordship. I have already supplied, my lord. If your lordship.
Yes, that's all.
That's
All right. You take up item 86, 93 and 95.
But one aspect, small, my lord, in item 86, just inform your lordship, the petitioner number 1, he was short of 1 mark and he attempted that question. Just for your lordship's knowledge.
Yes, but he is along with other petitioners, so we can't give him the benefit. That is the peril of joining petitioners. I'll mention it in the order. If he was separate, then he would have got a chance to participate, but now he is not. That is a price. No, sorry. Heard Mr. H.K. Das, learned counsel for the read petitioner in item 86 and Mr. K.P. Pathak, learned counsel for the petitioner in item 93 and 95. Mr. T.J. Mahanta, learned senior counsel assisted by Ms. P. Sharma has appeared for the APSC authorities. First up, the petitioners in all these read petitions had participated in the combined competitive bracket prelims examination, 2022, conducted by the Assam Public Service Commission, bracket APSC, in terms of advertisement number 26/2022, dated 22/12/2022. The preliminary examination consisted of 2 papers, namely VIZ General Studies dash paper 1 of 200 marks with 100 questions and General Studies paper Roman 2 of 200 marks with 80 questions. The qualifying marks for the General Studies paper 1 was fixed at 33%, whereas there was no qualifying marks for the General Studies paper 1. Paper 1, no qualifying mark.
Cut off, not,
But
I'm
sorry.
I'm sorry.
I'm dismissing your petition.
My lord, I'm
Sorry.
I'm
You
only
go in and appeal.
trying, no, my lord. I'd
Yes.
like to withdraw for the petitioner number 2 in 86, my lord. Lord, so will kindly bear with me, my lord.
Withdraw only the petitioner.
Petitioner number 2, my lord. She is
It can't
short
be
of
done.
3 marks, my
It
lord.
can't be done.
My lord,
You
on
cannot
lord, so will
withdraw
you
for-
only confined to petitioner number, that is my humble prayer. If
Sorry, that cannot be
I beg
done.
apology, my lord.
Show me a judgment, show me the law which permits it. Where is the law which permits it? Mr. Das, it was clearly pointed out to you in the first round when you withdraw that this is going to be perilous for your clients.
I segregated by
Now I'm
reasons.
dictating the judgment. Yes, no qualifying marks for the General Studies paper 1, though there was an overall cutoff mark. First up, the common case of the petitioners in all these 3 read petitions is that not only were the answers proposed by the APSC through the modified answer key wrong, but even the questions itself were incorrect, as a result of which it was not possible for any of the candidates to furnish a proper answer, full stop. The questions referred to by the petitioners are as follows. Number one, question number 11 of series A. Number two, question number 12 of series A. Number three, question number 4 of series of general studies paper 2, Upar give it general studies paper 2. Then number 1, question number 11, so and so, question number 12. Then question number 4 of series A. Full stop. Next, insofar as general studies paper 1 is concerned, the following questions have been found to be erroneous. Number 1, question number 80 of series A. Number 2, question number 39/A. Then question number 68/A. Full stop. It is the clear case of the petitioners that these questions were themselves wrong, and therefore the benefit of the marks awarded in case of correct answer for each of those questions, each of those wrong questions ought to be given to the petitioners, in which event they will cross the cutoff mark and therefore qualify for the mains examination. Full stop. Mr. T.J. Mahanto, learned senior counsel for the respondents, on the other hand, has strongly opposed this said prayer by submitting that the benefit of submitting that there are expert opinion to suggest that the questions are not wrong. Full stop. However, even if benefit of wrong questions is to be given to the petitioners, similar benefit will have to be given to all the 10,148 candidates who have qualified in the prelims examination, and therefore the petitioners would not cross the cutoff mark so as to qualify for the mains examination. Full stop. I find that there are altogether 75,000 candidates who had taken part in the CC bracket prelims examination, out of which 10,148 candidates have qualified for the mains examination. Full stop. The mains examination are scheduled to commence from 8th of July 2023. Full stop. Since the case of the petitioners is that the aforementioned questions were wrong, hence the question of figuring out the correct answer cannot arise in these matters, since there can never be a right answer to a wrong question. Full stop. Be that as it may, if the questions itself were wrong, then full marks in respect of each of those questions, that is 2 marks each, will have to be awarded to each of the candidates who had participated in the prelims examination, in which event the cutoff mark may rise by a few marks, but the same would not materially alter the merit position of the petitioners, since the aforesaid principle will have to be uniformly applied across the board with regard to all such candidates who had participated in the CCS prelims exams. Full stop. If that be so, even if the basic argument of the petitioners that the aforesaid questions were wrongly framed by the APSC is accepted, even then, the petitioners alone cannot be singled out for granting the benefit of those wrong questions and thereby qualifying them in the prelims examination. Full stop. For the reasons stated herein above, I am of the considered opinion that the relief as prayed for in these writ petitions cannot be granted in favor of the petitioners. The writ petitions are accordingly held to be devoid of any merit and the same are dismissed. Parties to bear their own cost. You now come to item 87 and 97. Here you write, heard Mr. H.K. Das, learned counsel for the writ petitioner in item 87, and Mr. K.P. Pathak, learned counsel for the petitioner in item 97. Mr. T.J. Mohanto, learned senior counsel assisted by Ms. P. Sharma, learned counsel has appeared for the APSC authorities. Full stop. The petitioners in both these writ petitions, numbering 4 in total, had participated in the that beginning part you add from here, CCS, prelims, so and so, so and so, so and so. Full stop. However, when the results were declared, it was found that none of the petitioners had qualified in the prelims examination, as a result of which they cannot now participate in the mains examination. Full stop. Aggrieved thereby, the petitioners have approached this court by filing the instant writ petition, inter alia contending that the answers provided by the APSC with regard to the questions referred to in the writ petition were incorrect, and therefore the petitioners have not only been wrongly denied of the marks relatable to those questions, but have even been wrongly given negative marking for the correct answer provided by the petitioner. Full stop. According to Mr. Das, the writ petitioner, the 3 writ petitioners in item 87 have given the correct answers, but instead of giving proper marking, they have been provided with negative marks. Full stop. Mr. Das submits that due to the ambiguity in the question itself, it was difficult to it was not possible to finalize on only one answer to the question. Under the circumstances, the respondents were clearly not justified in denying marks to the petitioners for giving the correct answer. Full stop. Mr. K.P. Pathak, appearing for the sole petitioner in item 97, submits that here also his client had given, here also the petitioner had given answer to question number, in your case,
Number 8 of series B.
question number 8 of series B of general studies.
1.
General studies 1 paper. Full stop. But the question itself was wrong. Full stop. Notwithstanding the same, instead of giving 2 marks to the petitioner, she has been given negative marking, based on which the petitioner has failed to qualify due to shortfall of 0.05 marks.
0.50.
0.50 marks. 0.50 marks in the prelims examination. Full stop. Mr. Pathak submits that since the question number so and so itself was a wrong question, hence the petitioner ought to have been given 2 marks.
But this one is GS paper 1 related, one is GS paper 2 related, my lord.
Yeah, I'll put the numbers. Mr. Pathak is GS paper 1.
GS paper 1.
Item 8, question 8.
Question 8 of series B of GS paper 1.
Acha. And Mr. Das, what are the questions in item 86?
Item 86, that
No,
same
86, no, 87, 87.
item 87 to Lakshana.
Which questions are wrong according to you?
Question number 11 of series A, 12 of series A, and 4 of series A.
11 of series A, 12 of series A, and 4 of series A. In the general studies paper 2. The questions are wrong.
No,
Answer key.
answer key is wrong. They said
The
answer key. is
answer
wrong.
key was wrong.
Answer key.
HK Das. And in case of KP Pathak, the question itself was wrong, negative marking. First of all. On such count, the petitioners have made a prayer before this court to permit them to sit in the mains examination so as to, as otherwise, the same would cause serious prejudice to their interest. Mr. Mohanto, learned counsel for senior counsel for the APSC, on the other hand, submits that the answer keys have been uploaded after proper verification of experts as regards to the correctness of the questions and answers. And therefore, this court, which does not have the expertise on the subject, cannot sit in appeal over the opinion of the experts. First up, it is also the submission of Mr. Mohanto that the answers provided by the writ petitioners were all incorrect, as a result of which they were awarded negative marking. Full stop. At this point of time,
Some petitioner, one of the petitioner given a correct answer, my lord. Out of this, my lord, got marked, my lord. If their version is correct, my lord, then he'll get.
Mr. Mohanto further submits that some of the petitioners have given the correct answers
Petitioner number 3 given correct answer, my lord.
as per the answer key published by
My
the APSC, and therefore the projection made in the writ petition, that is item number 87,
87.
is self-contradictory and hence deserves to be rejected by this court. Full stop. It is also the submission of Mr. Mohanto that if the prayer made by the petitioners is accepted at this stage, then the
Then-
same would open a Pandora's box, and a large number of candidates, unsuccessful candidates, will approach this court by filing similar petitions, which would make it impossible for the APSC to conduct the examinations within time. Full stop. By referring to a decision of the Supreme Court rendered in the case of Ran Vijay Singh and others versus State of Uttar Pradesh and others, reported in 2018 to SCC 357, as well as another decision rendered in the case of Uttar Pradesh Public Service Commission through its chairman and another versus Rahul Singh and another, reported in 2018 bracket close 7 SCC 254. Mr. Mohanto submits that even assuming that two views are possible in the matter, even then, the opinion of the expert submitted through the APSC ought to be accepted and the matter be closed, as otherwise the same would cause disruption of the examination process. First up, Mr. Mohanto has also argued that it is not for the court to reevaluate the candidature of the petitioners, and therefore no practical purpose will be served by keeping these writ petitions pending. I have considered the submissions made by learned counsel for both the sides and have gone through the materials available on record. It is to be noted herein that the case of the petitioner is not one of re-evaluation of their answer scripts, but one wherein it has been projected that incorrect questions have been set by the APSC, whereunder wrong options have been given, as wrong options have been provided as correct answers. Full stop. In the process, some of the candidates were given negative marking. Full stop. The learned counsel for the petitioners have taken this court through the questions, some of which prima facie appeared to be questionable insofar as the validity of the projection made therein is concerned. Questionable insofar as clarity on the question is concerned. Full stop. If the questions are not clear and are capable of dubious intention, and the candidate chooses one of the options which can be a possible answer to the question, can such a candidate be given negative marking for the answer? Is the question that would arise for consideration of this court. Full stop. This court has noticed that the petitioners herein have narrowly missed the qualifying marks, which in a way goes to suggest that if in the ultimate analysis, it is held that the questions complained of were capable of dual interpretation, and therefore more than one option would fit into the possible answer to the question, then in that event, it may not be correct to say that the candidate would have been given a negative marking for giving one of the, for choosing one of the multiple options. First step. However, such an exercise would be possible only after a detailed hearing of the writ petition based on affidavit filed by the respondents. First step. Since it is projected that the mains exams are scheduled from 8th of July 2023, and in view of the ensuing summer holidays of this court, it may not be possible to take a final view on the matter before the commencement of the final exams. As such, issue notice of motion returnable on 25th of July 2023. Since Ms. P. Sharma, learned counsel, has accepted notice on behalf of all the respondents, no formal notice is required. No, not all the respondents.
Four.
For
2, 3, and 4.
2, 3, and 4, and report given Mr. J.K. Goswami for respondent number 1. No formal notice is required to be sent in these writ petitions. Extra copies of the petition will be furnished to the learned departmental council. Full stop. Heard in the prayer of interim relief, this court does not intend to disrupt the process of mains examination at this stage. However, these writ petitions cannot also be rendered infructuous by not protecting the interest of the petitioners in the meantime. As such, it is provided that the 4 writ petitioners in these 2 writ petitions be permitted to provisionally participate in the mains examinations by fulfilling, if they fulfill all the other formalities except meeting the cutoff mark. First up, it is made clear that this interim order is passed in the peculiar facts and circumstances of this case, and considering the compulsions of this court to keep the matter alive. First up, any subsequent writ petition filed by unsuccessful candidate seeking similar relief would not be maintainable based on this order, in as much as this order would not create a precedent to be followed in other cases. Let these writ petitions be listed again on 25th of July 2023 as fixed items.
There only one difficulty. The portal was closed by which we are required to file application for the mains examination. That has to be taken care of by the APSC, Lord, perhaps. Offline.
I add one line, since the portal has already been closed, the 4 writ petitioners be permitted to submit their application offline if they approach the APSC authorities within a period of 3 days from today. along with a certified copy of this order. Mr. Mahanto, we are just having a look at the matter. It's not that any final.
I
relief is-
understand.
They will only participate in the exam. And in any case, what is the harm if young people want to write in exams?
No harm.
Four
But
out of 10,148, you will be 10,152. Heavens will not fall. So there is no reason to be upset about the order, but let them also have an experience. Maybe next time it will help them. If they don't succeed this time. Other matters, misjoinder of party is a very big issue, Mr. Das. You better understand it. You cannot club matters with diverse interest and conflicting interest in one case.
I understand.
And nowadays you have computers, you just need to change the name and take printouts. I don't know
But
how you missed
sometimes
out.
what happens when we try to cover up so many that.
Mr.
happens.
Das,
But anyway, Milord, I
there
understand.
are people who have gone through your stage earlier, or we know
Yes,
what is what.
I understand.
So let's not get.
But
into
even
all
then,
those
Milord,
debates.
we are obliged to your lordships for the patient hearing, Milord. And
No,
I beg
that's our
apology
job.
if at any point of time, Milord, I have
No,
exceeded
that's,
my.
that's your job, that's our job. We
But
are
like
all.
a small pair, my lord, in this earlier petition, my lord, there is a judicial order to produce the answer key, and along with we have also OMR also there, my lord. There's envelope is
You take it
there.
back. Take it
Yes, there will be a
Yes.
judicial.
Which is in which,
That earlier matter, my lord. Already they have withdrawn, my lord.
yes, yes. take
I'll
that.
take back, my lord.
Yes.
There is-
Actually, in the matters where it is disposed of, the earlier round.
That is still in the
First-
still cover, still cover. Yes.
Since WPC number 2384 of 2023 has already been disposed of by an order of this court, the answer key and the
Along with
OMR,
yeah.
original OMR produced by Mr. Mahanta in terms of the order passed in that proceeding, my lord, which has remained in the custody of this court so far, be taken back, my lord. The court master to do the needful for handing over the records.
My lord.
That is in the first three petitions which were dismissed. And let them write the exam. Let us see, let us apply our mind. Law is a evolving subject. It's a,
My lord, I understand.
it's an evolving
Yes, yes,
subject.
I do.
We
fully
ultimately,
agree with you.
we have
Fully
to
agree
look
with you.
into the society's interest.
I fully agree with your lordship, my lord. Under two item, my lord, item number regarding OMR, my lord. OMR not darkening, that's.
Actually, 88 and 94, what to do?
He's withdrawn already, probably he's not facing, my lord. We do not.
88 and 94, what are the
This
issues?
is with regard to Milord not darkening
No,
the
not
bubble.
darkening, that my lord,
of the
Supreme Court
OMR.
judgment is there, my lord.
So
that
I
is the-
tried to make an argument. I formulated an argument, Milord, but
Supreme Court, which judgment?
I have already placed, my lord.
We'll close it, Mr. Das. These are not
Lordships.
going to give. 88 and just take this, 88 and 94. You are appearing in 88.
yes, Milord.
Mr. Heard Mr. H.K. Das, learned counsel for the petitioner in item 88. Also heard Mr. K.P. Pathak, learned counsel for the petitioner in item 94. The first part will be same. Appeared and etc. etc. These are same. The petitioners in both these writ petitions were denied marks on account of the fact that they had not properly darkened
The series.
the proper series in the OMR sheet. First up, Mr. Mahanta, learned senior counsel appearing for the APC, has produced a copy of the
Judgment of one of the apex court and the division bench of the Rajasthan High Court, my lord, regarding that non-darkening
has
of the
relied upon the decision of the Supreme Court rendered in the case of state of Tamil Nadu and others versus G. Hemalata and others reported in
No, that is, my lord. That is reported in Monopatra, my lord. Yes, yes.
2019 bracket 5 bracket close ALT, all capital, ALT 103 to submit that. Which para?
My lord,
Milord,
para 7, my lord.
Milord, there is a division bench judgment of what this one was put on the same item.
That failure on the part of the candidate to follow the instructions of the commission
Are mandatory.
cannot be modified or relaxed. First up. As such, no relief can be granted to the petitioners in this case. Mr. Das, learned counsel for the petitioner, has also fairly submitted that a similar view has been taken by this court, by the division bench of this court, in the case of Assam Public Service Commission and another versus Ijaz Yusuf Ahmed and another, reported in 2019, bracket 3 GLT 754, wherein it has been held that non-marking of answers due to improper darkening of OMR sheets cannot be a ground of judicial scrutiny by the court. Full stop. If that be so, this court is of the opinion that no relief can be granted to the petitioners at this stage, since it is the admitted position of fact that they had failed to properly darken this series pertaining to the OMR sheets, as a result of which their answers were not evaluated properly by the computer. Situated thus, these writ petitions are held to be without any merit and are accordingly dismissed.
For hearing item 18.
What is the matter?
Please, your lordship. Lordship, the matter here pertains to selection and appointment of Gaubura, lordship. Here I have challenged this writ petition on the ground that the executive instruction with regard to the selection of Gaubura that has not been followed, lordship. That is the main ground here, lordship.
What is the executive instruction which has not been followed?
Lordship, the executive instruction, that is clause 162, lordship, I have a copy.
Clause 162.
Lordship, lordship, I have a fresh guidelines copy.
Now, can you please read out what is the instruction?
Lordship, 162(1), it lays down the minimum qualification, lordship. The deputy commissioner, principal secretaries of the autonomous council areas shall appoint Gauburas from the persons having the following qualifications. He or she should be a citizen of India and a permanent resident of the area in respect of which he or she seeks appointment. He or she should be of minimum 35 years of age. He or she should be minimum 10 passed from a board institution recognized by the state government. He or she should be physically fit and have sound mind. He or she should not have been declared.
All right, so which of the, which has
Lordship,
not?
the point 5, preference shall be given to the family members of the Gauburas and view of the Mozadar shall be taken into consideration. That was not considered in my case.
That is when only two candidates, both are on equal footing.
Lordship.
Then only preference.
Lordship, the selection has been held, lordship, and I secured less mark than respondent number 4, lordship.
Then how the preference can be given?
Lordship,
If you both had secured same marks,
no, lordship. I
preference
secured
can be given when both are equal.
Lordship.
But how can preference can be given to a poor candidate over a, you can't give a preference of a bad candidate over a good candidate. That's not a preference. That's favoritism.
Lordship, another point is he or she should have landed property, immovable property in his or her name in the area in which he or she intends to be appointed as Gaubura.
So what are you saying? The private respondent does not have landed property.
Lordship, that is, we have stated in our affidavit reply regarding some, we have annexed some documents. And another is, lordship, he or she should be a person of high status and command and have a respectable position in the society. Here, lordship, here.
High status, what? Should be status of what?
Lordship, in this regard.
What is a high status? Can you tell us?
Lordship, he should
Who are
be-
the people having high
he
status?
should be of good nature, lordship, amicable nature. lordship.
People with good nature are high status.
And the command and have a respectable position, lordship. That is the lordship in this case, lordship, there are certain criminal cases against respondent number 4, lordship. also we have annexed lordship and that is the main ground lordship. And regarding the awarding of marks lordship, the respondent number 2, they have stated in their affidavit that 10 marks are given to the candidate because I belong to the family of the Gaubra, 10 marks has been given, due weightage has been given. But if we go through the mark sheet lordship, that is not clear lordship, whether 10 marks is given or not. Because that is not
What is your
reflected.
case?
That is my case.
First of all, my friend is relying on a
You
guideline.
pass on the instruction. Agree to-
Lordship, this is the fresh
My
guidelines.
my
of
friend
the
is relying on a
publication.
guideline of 2018. When selection was held in the 2015.
So are you qualified?
Yes, my lord. As per the advertisement, my lord, I am qualified.
Where is the guideline of 2015?
2015 guideline, my lord, does not say about a person holding the landed property in the particular village, my lord. The landed property is there, but in the name of the father of the petitioner. And my lord, the cases, criminal cases mentioned by my friend, my lord, that all were filed by at his instance, my lord, after the selection was held. And those, in those cases, my lord, I have been acquitted already.
But all these issues need to be looked. Lord.
Moreover, my lord, this issue has been decided by the Honorable Division Bench that selection cannot be challenged. My lord, I have given the judgment, my lord. Judgment.
Which paragraph? Paragraph number?
My lord, no paragraph has been numbered in this case. Judgment, my lord. The last page number 7, my lord.
All right.
So, my lord, this repetition is not maintainable. But if they have any grievance, they can file appeal before the, my lord, commissioner of the division, my lord. In terms of the, my lord, executive
There is
instruction.
a stay order here.
Lordship,
ma'am.
here is a stay order.
Who is for the PNRD? Not PNRD, Revenue Department.
My lord, that selection and my lord, that everything will be done by the deputy commissioner. My lord, we are the, my lord, this, they have been done, my lord, whatever the advertisement, everything, selection process, so all have been done by the deputy commissioner.
So let the deputy commissioner verify and pass appropriate orders.
That can be done.
That's all.
Lordship, the interim protection that may be continued till the appeal will file an appeal. that
Which
may be
district is
continued.
this? Kamrup district.
Lordship,
Kamrup rural.
Kamrup Lordship.
Kamrup.
District of Kamrup.
All right.
No.
So you take down heard Miss. Miss A. Talukdar, Learned Counsel appearing for the petitioner. Also heard Mr. J. Hendrik, Learned Standing Counsel Revenue Department Assam appearing for the respondent number
1, Lord.
1. Mr. J. K. Goswami, Learned Government Senior Government Additional Senior Government Advocate Assam appearing for the respondent number 2 and 3. And Mr. I. H. Saikia, Learned Counsel representing the respondent number 4. Mr. It appears that the respondent number 2 had issued advertisement notice dated 4/3/2015, inviting applications for filling up one post of Gaubura No, one person, for filling up posts of Gaugura, including Gaugura of number 1 Bhakura Dia village. Full stop. In response to the aforesaid advertisement, the petitioner and the respondent number 4, besides other candidates, had submitted their application. On completion of the selection process, the respondent number 4 was found to be the successful candidate, and therefore he was recommended for appointment as Gaugura of number 1 Bhakura Dia village under Kamrup (R) district. At that stage, the petitioner had approached this court by filing the instant writ petition, assailing the selection of the respondent number 4 internally on the ground that the respondent number 4 did not meet the eligibility norms as provided under the advertisement notice dated 4/3/2015, as well as under the executive instruction framed under the provisions of the Assam Land and Revenue Regulation 1886. Full stop. Ms. Talukdar submits that as per the advertisement notice, preference was required to be given to the family members of former Gauguras. Moreover, executive instruction number 162 bracket numerical 1 bracket close, then bracket Roman 7 bracket close, also provides that as per the advertisement notice as well as provisions of 162 bracket 1 bracket close bracket small Roman 5, preference was required to be given to the family members of Gauguras, and the views of Mujadars was required to be taken into consideration, but no such exercise was done in this case. She also submits that as per Rule 162 bracket 1 bracket close bracket small Roman 7 bracket close, the candidate was required to have landed property within the area which the respondent number 4 did not have. As such, he could not have been selected for appointment in the post of Gaugura. Ms. Talukdar, however, has fairly admitted that her client did score lesser marks than the respondent number 4 in the selection process. Mr. Saikia, learned counsel for the respondent number 4 submits that the arguments made by the petitioner's counsel is on the basis of the executive instructions dated 10/4/2018, which was not in force when the advertisement notice was issued in the year 2015, and therefore the same would not have any relevance in the matter. First up, the learned counsel for the respondent number 4 also submits that the petitioner did have landed property, but the same was in the name of his father, which also meets the qualifying norms as provided, and therefore he did fulfill the eligibility norms as provided under the advertisement notice, as well as the executive instruction in force on the date on which the advertisement dated 4/3/2015 was issued. First up, Mr. Hendik, learned counsel for the Revenue Department submits that the issues raised in the writ petition would require factual inquiry, which can be made by the Deputy Commissioner of the district, and therefore the matter be remanded before the concerned authorities to take appropriate decision in the matter. First up. Similar is the stand of Mr. J.K. Goswami, learned government advocate Assam, appearing for the respondent number 2 and 3. It appears that due to an interim order dated
11/9/2015, Lordship.
11/9/2015 passed in this case. No order of appointment has yet been issued in favor of the respondent number 4. Full stop. Situated thus, and taking note of the submissions made by learned counsel for all the parties, this writ petition is being disposed of by providing that the respondent number 2 shall make an inquiry so as to ascertain as to whether the respondent number 4, respondent number 2, that is the Deputy Commissioner Kamruk Rural, will make an inquiry or cause an inquiry to be made by a competent person so as to ascertain as to whether the respondent number 4 did fulfill the eligibility norms under the executive instruction in force at the relevant point of time, as well as the conditions of the advertisement notice. If it is found that he did fulfill the required norms, order of appointment be issued in favor of the respondent number 4 without any further delay. The aforesaid exercise be carried out and completed within a period of 6 weeks from the date of receipt of a certified copy of this order. With the above observation, writ petition stands disposed of. And until such time the exercise is carried out and completed, the interim order dated 11/9/2015 shall hold the field with the above observation.
Much obliged, Lordship.
Or 81. Not possible, take a data.
Yes, my lord. Taken up.
List in the first week of August for hearing. Yes. List after vacation for hearing. Mr. Chetri, you are waiting for which case?
I'll have the Lordship fix the matter, item 2 and 3 for today itself.
Oh, it will come in the next list.
Lordship will fix.
Put it in the next list. It will come in the next hearing list again.
As further.
It will come in the next hearing list
Yes,
again.
Saying as further hearing or.
No, it will
or
come
part of
automatically.